Yeah, yeah, yeah. Yeah, yeah. Yeah, yeah, yeah. Yeah, yeah, yeah. Yeah, yeah, yeah. I don't know what song to sing. What day is it? Wednesday? Wednesday. Wait, is it Wednesday? Or is it Tuesday? It's Wednesday. Happy Wednesday. I knew that. Good morning. Welcome to Lolo's Lounge. Wake and Bake with Lolo. I am Lolo. Prince Spaghetti Day! Well, of course, Pepper. Good morning, my darling sister. How are you? It's good to see you. Hi, Teresa, my other beautiful sister. How are you? Pepper Anthony. I gotta get home. It's Prince Spaghetti Day. I think I just remembered that. Am I remembering it right? Am I remembering it right? I gotta get home. It's Prince Spaghetti Day. That's an old one. That's quite a throwback, Pep. Fuck yeah. Fuck yeah, Anthony. Anthony knows. It's time to go home and eat spaghetti. Oh my God, what a simpler time. How did we get, how did we leave such a simple time? That's what I want to know. Ay, ay, ay. Well, we've got a big SCOTUS hearing today on gender affirming care rights, and it's actually going to be argued by a lawyer who is transgender and will be arguing the case, and it's just very historic, and I'm very excited for them. I'm so grateful for this, but at the same time, I'm so fucking sick of people trying to tell people what to do with their bodies. I'm just so fucking sick of it. No one is mutilating children. No one. No one. 0 people. 0 children mutilated. 0. Okay? So all you little bitches out there who lose your shit because of transgender, and then somehow it always relates to children to you in your mind. So what you would do, you stupid idiots, is you would stand in the way of a person who knows what they want to do with their body, not your body. They don't want to do anything with your body, but they want to do something with their body. And somehow you have an opinion about that. Now, when you put it that way, I think it sounds pretty ridiculous that you would get an opinion about anybody's body. That sounds kind of ridiculous to me. And the bottom line is no one is mutilating children. Your children, their children, no one's children. They're getting the care that their child needs and that they and their doctors have identified that they need. So calm your tits, pay attention to your own dysfunction because you've got plenty of it, and go away. That's it. That's it. Kevin! Good morning, Kevin. Are you home? Are you home from the hospital? You're home from the hospital. Kevin, I love you. I hope you get what you need, and you just need to let me know about how it's going. I mean, if you need anything, but it sounds like you're going to get your surgery. You're going to get your consultation with a cardiologist, and I'm really happy for that. So take care of yourself, please. There are people out here who don't even know you, Kevin, who care about you. I don't even really know you, but I know you, and I certainly care. Yay, tomorrow. Okay. Well, best of luck. I know you will. I know. Oh, Kevin, I have such faith. I have such faith. But you hang in there, because I'm really grateful for your friendship. Let's see. Oh, so yes, today we're going to listen to the Supreme Court, and then we've got a ton of stuff. There's just everybody's come back with a big bang. So we're going to have all kinds of stuff. I appreciate you too, Kevin. I really do. You and I have been friends for a long time. So I appreciate you too. Butterflies are free. Butterflies, I love you. I really do. You're a great person. I see you. I see you in other places when I'm lurking, and I just want you to know, I just think you're a great person. I really appreciate you. You really stand up to people, and I really appreciate that. So I just wanted to tell you that because I noticed it. Yeah, I love you too. Yeah, Butterflies goes places people won't and stands up for things that people should. So I appreciate Butterflies for that very much. I see it all the time. That's right, one day at a time. So yeah, we've got tons. And guess what? Guess what else is happening? CPAC Argentina. Wow. A CPAC is still a thing. So that should be just wonderful. I can't wait. I don't know if any of the speeches will be in English. I suppose. I'm not sure how CPAC runs their overseas ones. I can't remember the Hungary one, if people spoke in English or they did. I don't know. And Brazil, there was one in Brazil too. Remember that? There was one in Brazil. Anyway. Lee, good morning, Lee. Good morning. Oh my goodness. Those are my favorite people. Everybody, all my favorite people are showing up. I'm so grateful. I really am grateful. Just another thanks. Thanks for being here. Thanks for being such nice friends. I really appreciate you. And Lee, did you see I tagged you in a tweet? I'm very proud of myself sometimes for tagging people in tweets. So I like to point it out. Because probably you did see that you got tagged in a tweet, but I don't know. Yeah, good luck with the specialist, Kevin. Yeah. Keep me posted. Keep me posted, my friend. Hi, Oomph. Good morning. Good morning. Good morning. Yeah, so in a bit we'll turn over to SCOTUS. We'll head over to SCOTUS, but in the meantime, let me see. We've got CPAC hasn't started yet. Oh, and you know what I'm going to do? I'm going to play a few like small news clips that explain what's going to happen, and this one is about the SCOTUS case we're going to learn today. So hold on, let me get it. Let me get it over here. Okay, here we go. 2 minutes.
In just a few hours, the Supreme Court will hear arguments about transgender rights.
It's over a Tennessee law that bans gender-affirming care for minors. Eyewitness News reporter Jaysha Patel joins us in studio with those details. Jaysha.
John Rachel, Tennessee and 25 other states have passed bans on some gender-affirming medical treatments for minors. The Supreme Court is asked to decide whether those bans are constitutional. The court will consider whether the Tennessee law that bars things like puberty blockers and hormone therapy for transgender minors discriminates on the basis of sex. Some medical organizations have endorsed the use of puberty blockers, hormone therapy, and in some cases surgeries, but other medical groups and conservative lawmakers say these treatments are inappropriate and dangerous. LGBTQ advocates claim the law violates
the 14th
Amendment's Equal Protection Clause
or psychologists?
Parental authority. And the outcome of the case could have a sweeping impact.
No, they own the Piggly Wiggly down the street.
300,000 American teens who identify as transgender. Meanwhile, here in California, leaders are trying to protect access to procedures for transgender people. Doctors who provide gender-affirming care in California are legally protected from laws criminalizing it in other states. Now, some experts have said that gender-affirming care could be threatened by federal action as President-elect Donald Trump is set to become president again.
Any
Trump
surgery is dangerous.
That's right. Congress to stop federal
but we still have them
from being used to promote or pay for these types of procedures. Now, today will also mark the first time an openly trans litigator will argue a case before the Supreme Court. A decision is not expected for several months, and the ruling could possibly affect other laws and efforts to regulate things like sports competitions involving transgender people or which bathrooms they even use.
Hello, I'm Mark Brown. Get more great ABC.
Kind of ridiculous, isn't it? What happened to freedom? I don't think Joan Rivers should have had her endoscopy because that's what killed her. Excuse me? Give me a break. So stupid. Anyway, so that's a little bit of the background. And of course, our amazing California. We're so great. When are they going to start CPAC Moscow? Well, I mean, be careful what you wish for. Let me see. I can put this. This is outside the Supreme Court. We could put that up. Make sure it's live. Oops. That's the Supreme Court right now. Everybody's real excited. Everybody's getting real excited out there. There's a lot of people out there. That's really great. I'm really happy. Do we see the right? I mean, are the people there to support, or it looks like they're supportive, I think. I see a flag indicating such. I don't know. I imagine. Yeah, I don't know when CPAC Moscow starts. Oh my God. What have we done? What have we done? What have we done? God damn. Okay, wait. There was some other things I had for you. Hold on. Oh, whoops. I don't need that. Oh, uh-oh. Somebody's breaking into my car. Hold on. Let me get another. Oh, my God. All right, hold on. I had a few little clippies for you. Oh, they're protesting in South Korea. We've got a lot. Oh my gosh. What's that? Oh, that's the ICC. I didn't watch any of that. I should have. Oh, you know what? I'm going to do that one. I'm going to use the PBS feed for the SCOTUS because I think they put the faces on of the people that are doing it. Backyard Bananas, how you doing? Down under. Is it like the middle of the night, Bananas? Well, welcome. I hope you have a great day. Keep thinking they have to find a way to swear Trump in. I don't know. I don't know what's going to happen. Hi, Carrie. How are you? Good morning. Good morning to you. Good morning to you. I think there was something else on. Wait a minute. Okay, so hold on. Date. Uh-oh, what do we got here?
Adults seeking to reform youth gender medicine.
Oh, it's that guy.
LGBT Courage Coalition seeks to impact culture and medicine to accept and support nonconformity in a non-medicalized way.
Oh, whoops.
Please join me in a warm welcome to Jamie.
Ooh, happy. So there's, oops.
My name is Jamie Reed, and I am a whistleblower from a pediatric gender center in the United States.
Oh, I see. So they're pro.
And a mom, and I
Oh,
also
no.
serve as the executive director of the Courage Coalition, a coalition of...
Why is he doing that when she's trying to speak? All right, well, I'm not going to stay with this. That's really good. I'm really happy that people are out there. Anyway, good morning. Oh, this is a great shot. Okay, that's a great shot. Never mind. Yeah, we'll just, never mind. Put that. Wah, wah, wah. Too many screens. Was a nice country, but oh well. Better luck next time. Better luck next time. Aw, Neil says, good morning, Kim. Good morning, backyard from Canada. Let's see. Carla, are you here? Carla, did you sneak in here and I didn't see you? Good morning, Carla. If I missed you. There you are. Yeah, so today we've got that. Wait, I had some other things. Hold on. Let me just find my little other thing. What do I have here? What do I have? Let me see. I had some clippy clips. Where are they? Boo doo boo doo 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 doo. Ba 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 ba. I didn't. Well, maybe I didn't. Okay, wait, where's my watch later? Watch later. Later. Oh, here it is. Oh, here we go. All right. So this is one I wanted to
South Korea's president
Stop!
resigned after his
Stop. I'm not a good producer. I'd be so much better if I had like a real producer, but we're not there yet. We only have 19 viewers. Okay, this is a little bit from NPR about South Korea. All right, so here we go.
his failed attempt to implement martial law this week. And the U.S. Supreme Court hears a challenge today to bans on gender-affirming care for minors. Good morning. I'm Corva Coleman from NPR News, and here are today's top stories. There are protests happening now in South Korea after President Yoon Suk-yeol's botched attempt to impose martial law yesterday. Opposition parties submitted a motion to impeach him. Now protesters are demanding his resignation. The protests are so heavy that busloads of police are arriving in the capital, Seoul, and other South Korean cities. The martial law declaration lasted about 6 hours yesterday. The South Korean parliament unanimously voted against it, and the president withdrew the order. A shaky truce in Lebanon will likely be high on the agenda this week when Secretary of State Antony Blinken meets his Israeli counterpart on the sidelines of a conference in Malta. NPR's Michelle Kellerman reports.
According to his spokesman, Israeli Foreign Minister Gideon Sa'ar will be meeting Blinken and the European Union's top diplomat, Kaja Kallas, in Malta. The trip comes just a day after Israel's defense minister, Israel Katz, was at the border with Lebanon, vowing to enforce a ceasefire and not let Hezbollah return to its, quote, old methods. Katz says if the Lebanese army does not do its part to push Hezbollah back, there will be, in his words, no immunity for the state of Lebanon. Under the U.S. and French-mediated ceasefire deal, Israel is due to pull out of southern Lebanon by the end of next month, and Hezbollah is supposed to move north of the Litani River. Michelle Kellerman, NPR News, Tel Aviv.
At the U.S. Supreme Court today, the justices will hear arguments in a case that tests whether states may ban minors from accessing gender-affirming care. NPR's Nina Totenberg reports.
3 Tennessee families are challenging the state law banning access for minors to puberty blockers, hormones, and other treatments for kids who say their gender doesn't align with their sex at birth. The challengers contend the law unconstitutionally discriminates based on sex because the banned medications are perfectly legal when used to treat other conditions in minors, conditions that range from chronic diseases like endometriosis to early or late onset puberty. The state legislature maintains that because it regulates medical care, it is well within its right to regulate medical practices that it claims pose a danger to the future health of kids under 18. Nina Totenberg, NPR News, Washington.
But they're not
President
doctors.
Biden is wrapping up his trip to the West African nation of Angola with a visit to the country's National Slavery Museum. He says the U.S. is working to face its history of slavery.
It's our duty to face our history, the good, the bad, and the ugly, the whole truth. That's what great nations do.
The site in Angola is where enslaved people were baptized
we
against
haven't,
their will,
but okay.
and their names changed before they were abducted.
I get it.
President Biden soon returns to the United States. You're listening to NPR News.
Thank you. Thank you, NPR, for that quick little update. Back over to you, Lolo. Okay, I'll take it from here. Anyway, so I just wanted to get that. See if I have anything else. Wait, let's see which I have 10 minutes. Okay. I have 10 minutes. What can I do in 10 minutes? Let me get my bookmarks out. What's that? Oh, we have some Russians arrested, which I'll read about for you. Let me read about the Russians being arrested for you. There we go. Celsius founder and former CEO Alexander Mashinsky pleads guilty to multi-billion-dollar fraud and market manipulation schemes. Whoopsie! Whoopsie! Oopsie poopsie. This is December 3rd. This is yesterday, I guess. Is that yesterday? I don't even know. Wait, can I make it bigger? There we go. All right. Damian Williams, the U.S. Attorney for the Southern District of New York, announced today that Alexander Mashinsky, the founder and former chief executive officer of Celsius Network LLC and their affiliated entities, collectively Celsius, pled guilty to 1 count of committing commodities fraud and 1 count of committing securities fraud in connection with 2 fraudulent schemes at Celsius, the purported bank of the crypto industry. Wow, I didn't know that. In the first scheme, Mashinsky misled Celsius's customers about core aspects of the company he founded, including Celsius' success and profitability and the nature of the investment Celsius made using customer funds. Oh, they just can't not touch customer funds. That's like the one thing you're not supposed to do as a fiduciary is touch the money. And there they go. They touch the money. It's really not hard. In the first scheme, okay, blah, blah, blah. In the second scheme, Mashinsky directly manipulated the price of CEL, Celsius's proprietary crypto token, no shit, while he was secretly selling his own CEL token at artificially inflated prices. No shit. As part of his plea, Mashinsky has agreed to forfeit over $48 million in proceeds from his illegal schemes. Mashinsky pled guilty today. Blar, blar, blar. Blar, blar, blar. Alexander Mashinsky orchestrated one of the biggest frauds in the crypto industry. He lured ordinary retail crypto investors, aka incels. No, I'm kidding. I'm kidding. With false promises that their investments were low risk. Well, okay. Using catchy slogans like unbank yourself. Mashinsky promised that Celsius would keep customers' crypto as safe as money in a bank. That's bullshit. But that, unlike a bank, Celsius returned most of the profits from his business back to users. Most. And by most, I mean probably none. In reality, Celsius was never profitable. To disguise the flaws in his business model, Mashinsky put investors' money into riskier and riskier bets and secretly used customer money to prop up the price of the token. Mashinsky made tens of millions of dollars selling his own token at artificially high prices, while his customers were left holding the bag when the company went bankrupt. Today's convictions reflect the office's... Yeah, okay. Well, that's great. Celsius was a crypto asset platform that, among other things, allowed its customers to earn returns on their crypto assets in the form of weekly rewards payments, to take loans secured by their crypto assets, and to custody their crypto assets. Oh my God. Celsius billed itself as the safest place for your crypto and urged potential customers to unbank themselves by moving their crypto assets to Celsius. The primary public offering was its Earn program, through which Celsius offered to deploy customers' crypto assets. I better pay attention to what time it is. What time is it? Okay, I've got money. I've got minutes. I've got money. I mean, Bitcoin. I don't know. Okay, through which Celsius offered to deploy customers' crypto assets to generate investment returns. In addition to its Earn program, Celsius offered retail customers a custody program and a borrow program, which allowed customers to receive retail loans in exchange for posting their crypto assets as collateral with Celsius. Mashinsky directly marketed Celsius to retail customers located in the U.S. and abroad through his tenure as CEO. He repeatedly made public misrepresentations regarding core aspects of Celsius' business and financial condition in order to induce retail customers to provide their crypto assets to Celsius and continue to use Celsius' services. Mashinsky misrepresented, among other things, the safety of the yield-generating activities, its profitability, the long-term sustainability of its high reward rates, and the risks associated with depositing crypto assets with Celsius. As Mashinsky falsely portrayed Celsius as a safe and secure institution, Celsius' customer base grew exponentially. Many of those customers were retail investors rather than large institutions. By in or about the fall of 2021, Celsius had grown to become one of the largest crypto platforms in the world, purportedly holding approximately $25 billion in assets at its peak. Gal, do you think it was Musk that put DeSantis in Trump's ear for DOD? Oh, I mean, I wouldn't be surprised about that. I wonder, is that what's happening? Is he going to be the head of DOD? Is that what he's going to do? What happened to Flynn? Is Flynn not getting anything? I'm just so confused. What's the game? What's the game with Mikey Flynn? Mashinsky and others working at it was the Musk Teal, et cetera, has always been the plan. Yeah. Mashinsky and others working at Celsius also orchestrated a years-long scheme to mislead customers and market participants regarding the market value and interests in Celsius's proprietary crypto token, CEL. They did so by manipulating the price through causing Celsius to spend hundreds of millions of dollars purchasing their own tokens in the open market with the objective of artificially supporting, oh my God. This is so, like, fucking simple. Yeah, well, that's right. Jim helped make Flynn toxic. Oh, fuck yeah, gal. Oh, fuck yeah. I love it. I love it. I love it. All right, I'll finish this and then I want to go to your thing. Actually, I probably won't finish this. I'll clip this, but suffice to say, another bad Russian. And you know how I love my Russians. Okay, let me see here. What do we got? What do we got? What do we got? Bingo. Oh. Oh. Whoops, where is it? Where is it? Oh. Oh. That it all makes sense now. Can you guys see that? I think you can. I love Justice. I love you, Justice. If DeSantis replaces Hegseth, Gates replaces DeSantis. There you go. That's why no Flynn. No Flynn because of Jim Stewartson. Oh my. No wonder they're all so very, very upset. And of course he said he isn't dropping out. What else is he supposed to say? What else? Well, hello, Paulina, my darling. Guten Morgen, meine Frauen, meine Frau. I don't know. Gotta go have a virtual therapy appointment. Kevin, love you. Take care. Kiss the puppies. Have a good day. I'll talk to you later, okay? Take care, bud. Big hugs. Well, there you go. DeSantis replaces Hegseth. Gates replaces DeSantis. Boy, you called this like 3 years ago. I swear to God, gal, you called this fucking 3 years ago. I can't. Okay, wait. I gotta find oh, yeah. Good luck, Kevin. Wow. That's crazy. This a little smaller, and then this a little larger. Do 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 do. Oh, actually, move this here. Boop boop. Booty boop boop. Boop boop. Booty boop boop. Boop boop. Booty boop boop. Boop 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 boop. It doesn't let you do anything until it starts. Interesting. Interesting. Well, it's just 7 now. I know. I'd rather be crazy kooky dummies who is always wrong. Yeah, but you're not. So blueing on it up, baby, because it's blue a true. Let's call it blue true. Blue bingo. Let's call it blue bingo. Bingo. I mean, you know, if they want to research it, they could do it too. It's not exclusive. You're in the dentist chair. True blue. All right, Doug Ford and DeSantis. Oh, Doug Ford. Ugh, everything's fine. Everything's just fine. Nothing to see. Oh, whoops, I made that really big, didn't I? I didn't mean to. I didn't mean to. I don't know why I did that. I'm sorry. Okay, wait. Here, come on, let's go. Come on, PBS, get your fucking act together. The other one's starting. I hate you. Start. Help a gal out, right? You gotta help a girl out and fix my grammar when you read it out loud. Wait. Oh no! It's no. Listen, my reading should not be a reflection on you at all. Hi, Iguana Sauna. Hey, Iggy. I'm waiting for this fucking Supreme Court. Brr. Wait. Okay, let me see which over here. Which is over here. Good morning to you, and this is my friends. Where is it? God fucking damn it. You know, nothing happens for a million years, and then all of a sudden they have 3 things happening at once. Fuck, man. I hate these guys. Getting shot. Wow, they're late. I don't see him actually starting any other channel yet. Yeah, I heard that. I heard that too, Neil, that Paula Ver is not very. Yeah, I hope that happens. Ford is renowned across Canada for being stupid. It's true. It's true. Well, is that playing? No. Okay, no one is. No, they're not. They haven't started. Somebody's pooping. Justice Alito, you should have pooped after breakfast. I mean, really, come on. What the hell? I've got 2 up just to see which one comes up first, but yeah, one guess as to how this will go. I know, Carrie. Oh, I know. I know. I wish I had more confidence that they would just look at the law in terms of what is right and what is wrong, but no, that's not the way life goes here. That's not the way. Kavanaugh's taking a big dump. Yeah, Carla. It's actually Brett. I'm sorry. I'm sorry, Alito. You pooped on time this morning. I know. I'm sorry. Sorry, bud. I'm sorry. It was definitely Brett. He's not that stupid. Oh, well, I mean, none of them are that stupid, Badger, because clearly they got to a certain point in their careers. So they're not that stupid, but they're stupid. I even think Doug Ford is stupid, and I don't really know that much about him. Kavanaugh's boofing. My God, they are taking a long time. What the hell? What in the hee-haw? What in the hee-hazzle? You have one job, SCOTUS. I'm boofing. I like beer. Oh my God. All right. Well, nobody's doing anything. How embarrassing. Oops. What's this? Interesting. Oh, okay. Well, I'm clicking on it. Why isn't it? Oh, there it is. Why isn't it coming up? A North Carolina town is suing utility Duke Energy over climate change. Fuck yeah. Fuck yeah. From today, from NPR. I'll read it to you while we're waiting for them to start. The small town of Carrboro, North Carolina, is suing one of the country's largest electric utilities, Duke Energy, over climate change. Beer, treasoning, bad choices. They might be having a fist fight, Carrie. It's true. While states and cities have filed lawsuits against big oil companies, suing utilities is less common. The arguments are similar, though. Carrboro alleges Duke knew about climate change for over 50 years, but continued to operate coal and gas power plants that spewed greenhouse gases. The lawsuit also says Duke participated in campaigns to confuse the public about whether climate change was real, to avoid stricter regulations. Duke Energy is the third largest source of carbon dioxide in the country, according to an analysis from the University of Massachusetts Amherst. That puts it well ahead of ExxonMobil and Koch Industries. The utility has 6 coal-fired plants in North Carolina. We need to protect our community from future harms, and this is why we find ourselves here as a plaintiff in this lawsuit, Carrboro Mayor Barbara Fushi says. Duke Energy did not immediately respond. In a complaint filed in a North Carolina state court, Carrboro is asking a jury to award the town money for current and future losses because of climate change. Our community floods regularly as a result of the supercharged storms that are dumping large amounts of precipitation in short periods of time, Fushi says. Hotter temperatures also create more road maintenance, and electric bills are higher in city buildings because they use more air conditioning, the complaint says. The lawsuit does not request a specific dollar amount, but Fushi says Carrboro has started tallying climate-related costs. Oh, that's a brilliant idea. We know that the...
This morning, case 23477, United States versus Scrimeti. General Prelogger.
Mr. Chief Justice, and may it please the court. For decades to treat many conditions, including gender dysphoria. But SB 1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as a gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients. SB 1 categorically bans treatment when, and only when, it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational. That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care, but here Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB 1 can be reviewed under the correct standard. I welcome the court's questions.
Much of your, the latter part of your opening statement suggests that it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's really for minors. So why isn't this simply a case of age classification when it comes to these treatments as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making that this isn't a sex-based line in the first place would equally apply in that context. But the court has likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how the state ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference if a girl takes testosterone or if a boy takes testosterone?
So the district court specifically considered this question in detail and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with the cross-sex use of the hormones.
Is there no physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth sex of who is taking those medications.
I'm more interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to in a female, and vice versa for estrogen.
So if you take hormones, they will prompt the development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth. And in fact, that's one of the intended effects of these treatments because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks and that it leaves regulation of medication unrestricted even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just...
Counsel, you rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig Reborn and some of the other ones where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset, and it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally, that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certainly the prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig v. Boren, different drinking ages, or Morales, can men and women adopt children in the same way?
And I think the court could recognize that that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there is some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second-guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think we're asking the court to break new ground in this case, and in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification, but then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
General, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition,
which Swedes were those?
We saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement
Why don't
that
you
there is
suck my
overwhelming
dick?
evidence establishing that these treatments have benefits that greatly outweigh the risks and the
Why don't you suck my
I,
fucking
of course,
dick?
acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the CAS report and Sweden,
Well,
but neither of those
can be
jurisdictions
medically necessary for some minors, but for the general run of minors, do you dispute the proposition?
That's
in
not
fact,
it.
that in almost all instances, the judgment
She's
at
not
the present
asking
time
for all
of the health
minors.
authorities
Oh, this
in
is
the United
dumb.
Kingdom
It's a
and
dumb
Sweden,
question.
is that the risks and dangers greatly outweigh the benefits. Do you dispute that?
I do dispute that, because if you actually look at how those jurisdictions are addressing this issue, they have not outright banned this care. The CAS report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course it's true that they have called for a more individualized and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that, that the
Then
National
don't.
Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and
So
are already
what?
on estrogen, but for those who
That's
are under
their
the
decision.
age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the CAS implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
And the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Isn't all of that true?
I believe that all of that's true. It's outside the record in this case, and so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Well said.
In your opening brief, you did not mention any of these European developments, and in your reply brief, is it not true that you just relegated the CAS report to a footnote?
So, Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically
and they
ban
all
it
of a
no
sudden
matter the
trust the
need.
Swedes?
With respect to the CAS report, that
break.
isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary Casp is not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief, that's obviously a facial sex classification, but our primary argument is SB1 is worded exactly the same way and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language in a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment. And the Court has addressed the question of how an equal protection claim should be analyzed when the law in question treats a medical condition or procedure differently based on a characteristic that is associated with just one sex. And
Why
that
does
was
Alberta have so many
Golding
crazy people?
in 1974, reaffirmed in Dobbs in 2022. And neither Bostock nor Dobbs
crazy
saw any
right-wingers.
connection between the Bostock reasoning and the Geduldig-Dobbs standard. Bostock did not mention Geduldig, and Dobbs did not mention Bostock. So why should we look to this Bostock-type reasoning here?
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the Court's approach in Bostock and what this Court has long done under the Equal Protection Clause. In both contexts, the Court has made clear that the right to equal treatment is an individual right, so you look at the particular person and see how the law affects them. And the Court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The Court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination.
Our experts in courts over here say it doesn't matter what happens anywhere else. So it's kind of like
we have the facial sex
cherry
classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the Court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose a statute said, let's just talk about puberty blockers.
You're in the right place, Badge. Don't you worry about it. You crank it up.
Puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty, so it's ruling out precocious puberty?
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex, and we're doing that because we have an interest in having minors appreciate their sex and not be disdainful
Well,
of
let
their
me
sex.
ask one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working, he gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs, and yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex, and that's imposing on the face of the statute two parallel rules
Totally
on
agree,
classes
Neil.
of people according to their sex. All adolescent males who want to take these medications
No, they
to
shouldn't,
feminize their
but
bodies,
I'm just saying they do.
and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through,
All right.
and I don't think it's controlled by Dobbs or Geduldig.
Thank you, General.
Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly, and I think that's an
here,
important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
With respect to the discussion about the European countries and the fact that they haven't limited these treatments
Badger
altogether,
has a big heart.
the Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected in the laws of those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against our, I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, to things that are wrong or right. For decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide?
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary?
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification, because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB 1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state, and it's true it arises in the context of medical care for transgender youth, but here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature
That's right, Carrie. Thank you.
That part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will. For a person born male who wants to get to puberty already,
right?
And you say that that's a kind of under-inclusion problem, and it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because
Paul,
you seem to want to say, no, you can do heightened scrutiny,
no one's
but you can
business.
also
it is not hurting
make
anyone.
Certain deferential moves towards the legislature.
Saving
I guess I'm pressing
lives.
you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated for all other purposes, and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, want to ask about our role here and pick up on the Chief Justice's questions at the beginning. Who decides? I mean, you've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20-plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law, and I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here, but when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court saying, looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is, then you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, I mean, the way you would think about this is, I guess, it prohibits all boys and girls from transitioning using certain medical treatments, and it doesn't say only boys can do so or only girls can do so.
Well, I think the problem with trying to put that transitioning label on it as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that for what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety for minors. You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind. And want to detransition.
And agree with you, Neil.
I don't think we can ignore.
So different,
we can't
the
ignore what you're
questioning.
talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or rational basis, those justifications for the state, how do we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
So let me react to a couple of different points you brought up.
It sounds like
First
you're
of
trying to
all, I do
diagnose
think
something
that the standard
medically,
of review
Brett.
very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that anytime the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first-order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern. And here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender-affirming care at all. And also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender-affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility, so I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity. With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks. And as I said before, I can understand that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB1 expressly permits, like on intersex individuals who often have surgeries as infants that might permanently affect their fertility. I would also say that if you are concerned about fertility, there are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rates of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is, you have this population of adolescents, and there are documented very essential benefits for a large number of them, and maybe a small number that will regret this care, just like with any other medical care. But for the state to come in and just say, across the board, you can't have the medication because of your birth sex, we don't think that's a tailored law.
You acknowledge there is some group, though, who later changes their mind and wants to detransition. That doesn't defeat your case. I just want to make sure you acknowledge there is
Shut the fuck up.
Some group of
Are you
people.
really?
Yes,
awesome.
yes. We're certainly not denying that some people might detransition or regret this care, but all of the available evidence shows that it's a very small number.
Then to pick up on the Chief Justice and Justice Alito's questions, it's obviously evolving debate. I mean, just in the last couple years in Europe, there's big changes in terms of how they're thinking about it and how they're thinking about these risks and benefits that you and I have just been talking about and you've been elaborating. If it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as, pretty heavy yellow light, if not red light, for this court to come in, the nine of us, and to constitutionalize
Whoever's sitting
the
next to
whole
him,
area.
pinch him.
The rest of the world, or at least the people the countries that have been at the forefront of this, are pumping the brakes on this kind of treatment because of concerns about the risks.
We certainly are not asking the court to set forth some bright-line constitutional rules in this space that is going to really take further debate and evaluation of regulatory options away from states. We think, as I mentioned, that the court really only needs to decide the first-order question here of whether this law classifies based on sex. I think that's entirely distinct from some of the concerns you've identified about what justifications the state has.
Oh my God, I'm so jealous.
West Virginia law
Hi,
you mentioned
Val.
is
I hope you're being safe, Gal.
I think it would
Love
likely
you.
satisfy heightened scrutiny. It hasn't been subject to adversarial testing because I don't think anyone has sued to challenge it, so I haven't looked at the record that West Virginia would build, but I do think that there is room here for states to enact tailored measures to try to guard against the kind of risks that you're concerned about and that the state has identified. And
last topic on the heightened review, and you say all we need to do is do heightened review, and that's kind of a minimal step. I mean, I'm not sure, really, that the follow-on effects of that could be pretty significant. I think Justice Kagan alluded to to that in her question, or at least raised that as a question, and want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports?
This has fuck all to do with
basketball,
anything,
swimming,
doesn't it?
volleyball, track, et cetera, notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case. So can you explain how intermediate scrutiny would apply to women's sports?
Yes, and just as a threshold clarifying point, I want to be clear that when it comes to access to sex-separated spaces like sports and bathrooms, courts already recognize that those are facial sex classifications that trigger heightened scrutiny. So it's actually not the question teed up here about how to classify the law in the first place or how to identify whether it's a sex classification. Instead, that's taken as given in that litigation, and the entire focal point of the disputes in those cases has been, well, does the state have an important governmental interest and doesn't need to draw the lines to exclude transgender people?
Right, but how would intermediate scrutiny, which we may not, if we went to intermediate scrutiny, there's a possibility we would apply it here. How would it apply to, in your view, and maybe you don't have fully informed views, which would be fine, but how do you think it would apply to sports?
So courts have split on that issue, and I hesitate to try in a vacuum without an actual factual record to try to opine on the state's justification and whether it will satisfy that standard. It's obviously a different set of governmental interests that are being asserted there, and those would have to be analyzed in their own right. But I think that this court, if it wants to preserve space to make clear that nothing here should be understood to affect the separate questions that are arising there, the court could very well do so, and we would have no objection to explicit language saying this decision does not in any way or should not be understood to affect the separate state interests there that have to be evaluated on their own terms.
Okay, but looking ahead, do you think it's logically possible as a matter of constitutional decision-making to say that laws like the one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny? Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think
we have to have a movie night tonight.
Apparent difference is that in the context of sports, there are arguments made that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts. There's nothing like this here. Allowing transgender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people. And so I think the court could well understand the statute here to fail intermediate scrutiny, even if it would survive there.
Thank you.
Justice Barrett.
Morning, General. I want to pick up on one of Justice Kavanaugh's early questions. You know, he pointed out that the burdens of the law fall equally on boys and girls because neither can transition. And you responded that it's kind of the sex classification or the expectations that one will conform to one's, biological or gender assigned at birth. Why isn't that more of an Arlington Heights argument about intentional discrimination than if what you're really saying or what the legislature is really saying is the burden of this is going to be equally applicable. Neither boys nor girls can have access to these drugs. But the reason why is because we want girls to be girls and boys to be boys, at least until they're old enough to decide otherwise.
So I think it would be wrong to overlook the fact that even separate and apart from any interest
such a
in
good
conformity
point, Carla.
here or sex
Traumatized
stereotyping,
people are easier
this is
to
a law
control.
on its face that does not subject boys and girls to equal treatment. And you can see that if you look at how the law applies to some of the individual plaintiffs.
That sounds like
Ryan
heaven,
Rowe,
Val.
who is one of the individual plaintiffs here. He wants to take testosterone in order to live and identify as a boy, and he's prohibited by SB 1 from doing so because his birth sex was female. But if you change Ryan's birth sex and suppose he was a assigned male at birth, then SB1's restriction lifts. So he is not being treated the same as a boy, who was assigned male at birth. And I think that is the kind of quintessential test the court has applied for purposes of identifying when there's a sex classification.
So what would your argument be if a new drug is developed within, say, 2 or 3 years, that just the only purpose of the drug, there's no precocious puberty purpose or anything like that, the only reason to give this drug is it targets minors who have gender dysphoria particularly, and a state passes a law, the FDA approves it, so it's available in some states, but a state passes a law saying no one has access to it. So now you don't have that whole thing falls out.
Yeah. So that would not be a facial sex classification. And there I do think that you would have to apply an Arlington Heights type of analysis to see whether the context and history demonstrate that actually the state was intending to treat people differently based on their sex. But I think that would function very differently from SB1.
Why don't you have an Arlington Heights argument here too? Because I take it one thing you think would be wrong with that law is the stereotyping function.
Well, I think that Arlington Heights doesn't seem like the natural doctrinal home for a law like SB1 that says on its face you can't act inconsistent with sex. And I take your point about that's applying some equal rules to boys and girls, but that's true anytime you have a law that says you can't act inconsistent with a characteristic. That means that there's going to be a restriction on males and a restriction on females. It's true of any other factor too, inconsistent with race, inconsistent with religion. You might say, well, that's not just singling out one religion or one race or one sex for disparate treatment, but I think it actually increases the number of classifications when you're applying parallel restrictive rules on the basis of a protected characteristic across the board.
So let me return to Justice Kagan's questions. She asked you whether really the more natural way to think about this is that it is discriminating on the basis of transgender status rather than, I feel like trying to make the Bostock-like argument, holding all things equal, or that you have to do this by reference to, biological sex, feels like an odd way to solve the problem, and kind of that hypothetical I gave you about the drug that just has the transitioning purpose. So if we just head-on confront the question which you raise in the second part of your brief about whether transgender status should be a suspect class, one question I have is, at least as far as I can think of, we don't have a history of de jure, or that I know of, we don't have a history of de jure discrimination against transgender people, right? You point out in your brief that in the last 3 years there have been de jure. But before that, we might have had private societal discrimination. But I don't know of, but is there a history that I don't know about where we have de jure discrimination? And my concern about it is this: all of the other suspect classes that we've recognized so far do have that long de jure history of discrimination. And the Equal Protection Clause applies to state action, so it feels like an odd fit to say that in their private lives, people have
Bye, Pepper. Love you, girl. Bye, sister.
Therefore, we're going to
3-hour
treat it as a
meeting.
suspect
Suck
class
it.
for purposes
That's
of the Equal
terrible.
Protection Clause.
So I think you may be right that the discrimination, historical discrimination against
Go get 'em,
transgender
Pep.
people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here, and it hasn't just been confined to private actors.
Absolutely.
I think that if you
And guess
actually
what,
looked at
Butterflies?
the
The good news
there's
is there are
a wealth of
parents
evidence to
and
suggest that transgender
caregivers
people
and
throughout history
therapists
have been
and
subjected
psychologists
to violence and
and medical
discrimination
doctors
and maybe lost employment
and all
opportunities
kinds
or
of
housing
experts
opportunities,
surrounding
even in
that
contexts where
child
there
as
might be
they
state
make
public
that
employment at
very,
play.
very heady
And of course,
decision.
that's especially
So
reflected
I
now
appreciate
in the
what you're
law
saying.
where
Of course,
there has been
any
this,
surgery
I
on
think,
any
attention and
child
focus on
gives me great
trying to limit
pause.
transgender people from
And I
being
can
able
only
to live
imagine
and
that it is
identify
absolutely
consistent with their gender
compelling
identity in our
for
society.
families
So
who are
I
going
don't even
through it to
understand the
make
state
those
to be
very,
disputing the
very grave
historical discrimination
decisions,
point.
serious
But if you're
decisions.
approaching this from the
I
standpoint
trust
of
them to
saying,
do
is
it.
this a group
That's
with
the
a
difference,
distinguishing
right? Is that
characteristic
you
that
and
has
I
no
trust
bearing
them
on their
to
ability
make
to
those
contribute
decisions,
and that needs some protection
understanding
from the
the
courts.
gravity
I
of
think
the
if any group
situation.
qualifies, this
So
one does
yeah,
in light of the
absolutely,
current
I agree
laws
with you.
and what
I
might
agree
come
with
in the
you.
future.
Yeah, I
And
don't
our
want
basic
to.
argument is if you can
It's
look ahead
upsetting
and
that
say,
any
maybe the
child
states will
has to
ban
go
medical care
through
for
that
adults
in
who
order
are
to be
transgender.
in their
Maybe they'll ban
bodies.
adoption by transgender people. We'll
Yet
not allow them
these
to
are
be
the treatments
teachers.
that help them
That doesn't look
achieve that.
anything like the workaday
yeah, I
economic
agree.
regulation that just gets rational basis review. And I think the court could give effect to that intuition.
Yeah, and I don't want to be misunderstood to say that I don't think there's a problem or that there hasn't been private discrimination. I guess it doesn't seem analogous to me to say race or gender or national origin, those kinds of things, because we did have de jure discrimination to point to. And so I guess what I'm thinking is when we are in the business of identifying suspect
I think
classes,
Val, I think they actually
in
administer
Cleburne,
puberty
we
blockers and
expressed-
other
I'm not saying that this is
hormonal
analogous
treatments
to Cleburne
in
in
certain
that
cases.
respect, but we
So there is
expressed in
some
Cleburne,
change prior to
hesitancy,
going through
you know,
puberty.
to identify groups such
But
as the
they've
elderly,
made it clear it's for good
you know, or
medical
the mentally
reasons around
disabled
gender
as suspect
dysphoria
classes, in
and
part
severe
because those are
mental
judgments that are pretty
effects
hard
of
for
that on
courts
a
to make.
child.
And at least de jure discrimination of the sort experienced by women, you know, or people on the basis of race. Gives
Yeah,
us
I believe
something
so.
to point
I believe
to
so.
If we're going to be identifying a new
I
suspect class, which we
I would
haven't done
think
for a
so,
long time.
right? That would make sense
and
to
I,
me,
of course,
just from a
take that
developmental
point, and I should
standpoint.
reiterate, we don't think the court has to confront
be
it
wrong,
here.
but-
in the cases involving age and disability, I understand the court to have approached those issues with somewhat different reasoning, that age is something we all experience, that disability is a broad and diverse group, and that individuals with disabilities have been able to harness the majoritarian political forces to protect their rights. And none of that is true here. Transgender individuals are a discrete minority. I think there's no dispute that they are being subject to a wave of legislation across the states today. And I think that this is the kind of circumstance where the court could rightly recognize that heightened scrutiny should apply.
Last question. Do you agree with me that the resolution of this case has no impact on the parental rights claim that the Sixth Circuit also addressed?
That's right. I think we are not making a substantive due process parental rights claim here, and this court obviously didn't grant review of that issue. I will say that I think parental rights are actually relevant to the Equal Protection Clause as well, insofar.
I'm sorry, I've got to interrupt it. Half an hour ago, the CEO of United Healthcare was shot and killed. Hold on. Outside a Midtown Midtown Manhattan hotel. Hold on. Let me grab this story. Wow. That's kind of insane. All right, hold on. Come on. Where are you? Oh, here it is. Okay. I'll put it over me. Okay.
To their offices for work, a 5-minute walk maybe from Radio City and the Christmas tree, which, as Phil says, is getting lit tonight. What's your reaction to hearing that someone was able to pull off an attack like this in that area? And what's your advice to people in the city now with this gunman still on the loose?
Well, Diane, it's interesting because this is probably one of the biggest days of the year in Manhattan for the holidays. It's the tree lighting. And all those resources go into that. And here's the thing. In 2017 on Halloween, we had a terrorist attack on the West Side Highway. Just a few blocks over, we still had the Halloween parade. So
I'm
it's
sorry
not
to
going to
interrupt
stop the
the
tree lighting.
court. I'll
That's for
come back
sure.
to that.
It's important to understand it's targeted. It's not random. It's not a terrorist incident, what we can see right now. That you're still safe to go to this. There's a lot of tourists come to New York City just for this moment. It's really the kickoff of the holiday season as well as Thanksgiving. This is even bigger. More people go into the area. You're going to see a lot of police officers deployed in the area. It's going to go on. It's not going to stop. And I have every faith in Manhattan South homicide detectives. They're going to solve this crime. And they're going to follow this and go all the way back and see what's and see where he goes. And when he makes that first mistake, he pulls off that hood. And that's important.
And Robert, as soon as you say something's targeted, it begs the next question as to, okay, so what was the motive here? Why was this man being targeted? Does that help when you're trying to find a suspect on the loose, giving you the opportunity to look for people who had some kind of vendetta, some kind of motive for this, even if you don't have any physical ID on the suspect?
You know, Diane, that's a different part of the investigation. You look towards motive. You look towards the threat level. And that's, did anybody make a threat against this individual? Was it this disgruntled client? He is this United Healthcare has 29 million clients. That's a lot. But what was going on in his life at this time? Was it a threat from a client? Was it other business dealing? We don't know right now. Most importantly, is this video canvas right now, and see where it goes. I'll tell you, it'll pay its service to the investigation if you follow it all the way to wherever this man's going. The fact that he had a bicycle. He left that backpack on, makes him distinctive now. He's different than the crowd. So it's actually even easier to follow him now than it was before.
And Phil, I know it's really limited right now, but what do we know about Brian Thompson at this point, the victim here?
Yeah, ABC News did have the opportunity to speak to his sister-in-law as she was on her way to his wife's home. And you know, she said that we are all just really sad right now, and did bring up the fact that he has 2 children, one college age and one younger than that, and that she didn't know much else about the incident.
Such a tragedy for that family. ABC's Phil Lipoff, former NYPD Chief of Detectives Robert Boyce, thank you both. And President-elect Trump's Pentagon pick could be in jeopardy.
No, to say it isn't so. Well, that's kind of crazy. Wow. Let me go back. I'm going to, sorry. Go back. Nope. Don't hide that one. Hide that one. This is something Gal sent. That's the picture. That's the link she just put. Scott's post about the killer. I know. I do too. All right, let's go back to our Supreme Court. Our other nightmare, known as the Supreme Court. Nope, that's not it. That's it.
As it's significant to me that Tennessee, in choosing to categorically ban this care, is taking a sharp turn away from how it ordinarily handles parental rights in the medical decision-making space. And Justice Kavanaugh said, who decides here? But when it comes to medical risks and benefits, the state's general approach is to say parents get to decide along with their doctors and their children. And so I think from the standpoint of under-inclusivity, it's pretty significant that Tennessee now is completely overriding parents' wishes when they are best positioned to know their individual child and to have a good sense of whether the risks of this treatment are outweighed by the benefits.
But this isn't, I guess my point is, even if we decided that this wasn't a sex-based classification that triggered intermediate scrutiny, that would not prevent parents from still asserting the substantive due process right.
Yes, of course, I agree with that. I do think that the sex-based classification under Equal Protection Clause is the most straightforward way to think about what's going on here, though.
Yeah, thanks.
Justice Jackson?
So I'm glad that you've clarified that how we characterize this law is really the issue on the table today, not the risks or benefits or the policies that justify it, but how we characterize it. And I guess I think there might be some confusion a little bit, at least I'm confused, because there's so many lines that this statute could draw. The classification, as far as I can tell, is a line drawing, is the statute drawing lines, and there are lots of different ones. And Tennessee says this is drawing a line between people on the basis of age and purpose, and I totally see that. You say this is drawing a line on the basis of sex. I see that as well, but I guess my sort of initial question is, are those mutually exclusive? Do we have to choose between those characterizations? Isn't there a world in which this statute is doing both of those things? And the question for equal protection purposes is, if you're right that there is a sex-based line being drawn, then to the extent the plaintiffs are implicated by that line, don't we have to apply heightened scrutiny in evaluating their claims?
Yes, that's exactly right. And I think, of course, you could say this is a statute that classifies based on age and purpose and sex. Critically, we think that purpose incorporates sex here because the purpose is expressly defined in terms of treatments that are inconsistent with sex. Right. So I think the problem with the state's approach is to say, well, it's just purpose going on.
Actually, you're absolutely right,
and
Neil.
that just dissolves down into drawing a sex-based line itself.
Can we put more
Everybody's
flesh on
in
that,
charge.
though? Because I mean,
It's a collective.
even if we separate out their age and purpose, and we just say, okay, so how is this actually drawing a line on the basis of sex? I think I heard you say it a couple times with respect to some examples, but I think it would be helpful to get on the table exactly who's falling on what side of the line in a particular situation related to sex.
Yes, so the way that the sex-based classification is working here is that from the standpoint of any individual who wants to take these medications, their sex determines whether SB1 applies. John Doe, one of the plaintiffs, wants to take puberty blockers to undergo a typical male puberty. But SB1 says that because John's sex at birth was female, he can't have access to those medications. And if you change his sex, then the restriction under SB 1 lifts and it changes the result.
No, gal,
and my
no.
friends say, well, that also simultaneously changes the medical purpose of using these medications. We don't dispute that point, that it might also inherently change purpose when you're changing sex.
But it doesn't have to, right? I thought of an example in which we have a plaintiff, a person a minor, who would like to take this
pays off,
medication
okay?
to affirm
Loyalty
their
fucking
gender
pays
as
off.
a
That's true. He
male
did write that
because
section.
the
We even read
medication
that, I
deepens
think.
their voice, for example.
I think
They
that's
want
one
a
of
deeper
the few
voice,
we read.
And they're biologically male. They're taking the medication because that's what they want. They, I think, can get that medication.
That's right. And
but
so
a person who is
I
biologically
adore
female
when you
who
guys
wants to take the
talk
medication
and
for
have
that same
conversations
purpose,
outside
to deepen
of
their
what we're
voice
talking. I just
because
think
they would like to
that
live
to me is
as a
community.
male,
And
can't
that's
get
so
it.
great.
Is
Yeah,
that
no,
right?
I understand,
And that is
Neil.
on
I
the basis of
appreciate
their
that.
sex.
Thank
so
you
the
for
purpose is held constant
respecting
with that
the
example.
channel,
It's
but
not
you
changing.
guys
What is
are always
changing
on
is
point.
just
So
the biological
I
sex of the individual.
I couldn't be more delighted when you
that's
guys
correct, but
take
even in a
it where you want
circumstance
to
where you
take
might
it.
characterize that as treating delayed puberty instead of gender dysphoria, if you said, well, there is a different purpose there, even though the effects are exactly the same and they want the medications for exactly the same reason, that doesn't eliminate the sex-based classification because sex only has to be one but-for cause of disparate treatment. And I think the state will say it's perfectly reasonable to treat different medical purposes or uses differently.
We're just going to change the words to that
but
song.
that's something that's channeled to the application of heightened scrutiny. And if the state has a really good reason to say there's a danger in using these drugs if your birth sex was female and you want to deepen your voice,
Right,
and it's different.
so that's Justice Alito's studies in all of this.
Exactly. That
can
all
come in
goes
at that
to the
point.
application of heightened scrutiny, and maybe the state can prove it up and show they have an important state interest, and they really have a reason to distinguish between who can have these drugs for which purposes based on their sex. But that doesn't eliminate the facial sex classification or provide a reason for this court to turn its back on 50 years of precedent, saying if you classify based on sex, you have to justify that.
And it's interesting to me that you mentioned precedent, because some of these questions about sort of who decides and the concerns and legislative prerogatives, et cetera, sound very familiar to me. They sound in the same kinds
Paul
of
J.
arguments that were made back in the day, 50s, 60s, with respect to racial classifications and inconsistencies. I'm thinking in particular about loving, and I'm wondering whether you've thought about the parallels, because I see one, as to how this statute operates and how the anti-miscegenation statutes in Virginia
100%, Neil.
Yes, and I think the court has recognized that the Equal Protection Clause was intended to force some changes in society and get us to think more closely about the way that people were being classified, including when that was based on overbroad generalizations of how we expect them to live and order their affairs. And the court has made that clear in the sex discrimination cases as well, where it said sometimes these laws operate to disadvantage someone who falls outside the average description, and that person needs the protection of the court.
Well, and the thing I thought what was most interesting about the potential comparison to Loving is that in that case, everyone seemed to concede up front that a racial classification was being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic, and in all other contexts, the court has recognized that as a facial classification based on that characteristic, and Tennessee even concedes the point when it comes to dress codes and to seeking a profession inconsistent with sex. But I think one other way to look at this, Justice Jackson, is that, to me, it would be a remarkable proposition for this court to say that a statute that on its face says you can't have medications inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground.
Thank you.
Thank you, counsel.
Here's to helping.
Mr. Strangio?
Mr. Chief Justice, and may it please the court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too. By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
If you are successful, what would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB 1 as applied to our individual plaintiffs.
So in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex?
In practical terms, what it would mean is that an individual like John Doe, who is receiving medical treatment to undergo a typical male puberty prior to SB 1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of review, that it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think, as the Solicitor General made clear in her remarks, that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the
first transgender lawyer to argue before the Supreme Court.
Is there anything you would like to add, and maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus
I should say openly transgender, forgive me.
Morales.
First openly transgender lawyer to argue in front of the Supreme Court.
Stereotyping with respect, can men have the same rights as women with respect to adoption and the liquor laws? This does strike me, whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases?
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence, as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether the classification is benign. And
yes,
many,
Chase Strangio, thank you so much. The name of this attorney is Chase Strangio, first transgender lawyer to openly transgender lawyer to argue
by the court under rational basis.
Historical
and the
moment.
role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counsel, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means ends calculation in this kind of medical context? Because I agree with you. I mean, I can see your point, like, well, you know, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, you know, undeniably in areas of public health and evolving science, and the court repeatedly made clear that yes, of course, the states have latitude
parents'
through
rights
their
and
police
to a
power
point, I
to
guess.
regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard
Parents'
that
rights
the
to a
courts
point.
apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some. Can I just this last follow-up? But even in those COVID-19 cases, you know, courts weren't, and we certainly weren't, diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie and exactly what the difference is between that 1% of children who receive these treatments expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we address this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, Counsel.
Could we explore what
Boom.
intermediate scrutiny might look like in operation in assessing laws like Tennessee's? So the Solicitor General on page 48 of her brief lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent,
that's the way. Kids don't do that.
Readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in
Yeah,
response,
here we
Justice
are.
Alito. And the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law, and if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many, many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned
BRB.
in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point, if I could, to the history of discrimination, and there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
I think
somebody was trying to make.
Yes, I think it was me, and the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence, and I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It is not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. If this is similar to that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, or not the Tennessee court, this court is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications, it's more questions of constitutional allegation of authority. And, we may think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor. Particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Right.
What you think?
Mr. Chief Justice, if I could first respond to the first half of your question
Exactly,
about
Neil.
whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to
Opus
to
Dei
minimize
in the
them.
house.
Here what they've done is impose a blunderbuss ban overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas?
The point I was getting at with respect to remedies is normally in equal protection
Nobody
cases, there's a
cares.
difference between one group and another. In Bourne, it would be that the women could buy alcohol, but the the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys, and what birth females can do that birth males can't do
Carla.
is receive medical treatment to live and identify as girls. That's
Okay,
at the group
let's
level.
change. Would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose, and what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
So beautiful and simply put.
Finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth, sex, and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of, does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections, and I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that distinguishes on that ground is not a suspect classification? And I'm not suggesting that gender dysphoria is a disease.
Fuck? Yeah, you are.
I'm not suggesting that at all. I'm just saying,
no,
how
you
could we
really
justify
are.
the different treatment?
I think that
It's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Two completely different diagnoses?
The difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that
And
group
this
of
isn't
people
a
had been
disability,
able
it's
to,
completely
secure
different.
some protection through the legislative process.
Oh my God.
But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is a law that I think is easiest to understand and in the most straightforward.
She's bringing you back down to earth.
So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct, Chair.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights perhaps question, but the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB 1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply a rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it. It's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the
If
issues.
you go
the
up, I'm
treatment's
just going to stop
barred-
it since we're still a little behind. If you go up to the link that I've posted, it's a gift link in the chat, and it actually is following the arguments. And I may have misgendered Chase Strangio, so forgive me. He. It has a TikTok of the arguments with some analysis embedded in it. So follow, if you go to the gift link above that's pinned, it'll give you background as well as ongoing analysis to the arguments. Sorry to interrupt.
Some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me. But it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed. And then the question
Which is not a
becomes,
decision
how does
for the court to make.
choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay.
Harmed by what?
So if I could just make a few points in
Okay,
reaction.
I had one more point,
Okay.
sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have the same discussion as I see it. So just to get you thinking about that too. Go ahead. Have at it.
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors.
What happened to we
based
believe
on claims
parents?
of
We trust
harm,
parents.
That protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that with respect to the difference between rational basis and heightened scrutiny, yes, of course it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny, and we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient?
Well, can I just stop
well
you there?
said, Carrie.
If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to there are risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
They're going to end up banning circumcisions.
Just one point there. You agree that there's some group of people who receive the treatments who later wish they hadn't.
God!
And wish to detransition. I know you say it's
Shut
a smaller
up.
group. I understand that. I just want to make sure you
Shut
agree
the
as a
fuck
factual
up.
matter.
Smaller group as in not relevant, not a significant number, not statistically relevant.
And then on the sports question, I want to get you
Oh my God.
reaction as well.
He's going to bring up
Is
bathrooms
it
next.
logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would
He
be
didn't get a chance to please his boss, Leonard Leo.
I agree with the Solicitor General that it's legally and logically possible because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trangelo, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life, and there is a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Apparently.
Thank you.
Justice Jackson?
So I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening, what is the justification, and you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that, and the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or what the state is, why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says, the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots
Loving
of good
was
reasons
the
for
landmark
this
case
policy, and
around
who are we as the
interracial
court
marriage,
to
Badger.
say otherwise. I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that...
Okay, so in the link above, they do a good job of defining heightened scrutiny. So that's something that might be important. But what Justice Jackson is equating, what she's saying is that I'm getting concerned because I'm starting to hear justification for a law that is only specific to a certain gender assignment at birth. And what I'm hearing is the same arguments made in defense of prohibiting interracial marriage. So she's saying, I'm getting concerned that I'm hearing the same arguments by courts being made that were made to try and oppress interracial and make interracial. Loving v. Virginia should be the precedent here. Yes. Thank you. Oomph, that's better said. But do check out the link above. It's a gift link, and it has the TikTok of this case hearing and some great mini analysis. All right, I'll shut up.
Biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel. Mr. Rice?
Mr. Chief Justice,
very important.
and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question.
Neil.
Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policymaking. As Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, Counselor. Every medical treatment has a risk, even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other, one person of one sex from another sex, from receiving that benefit? So if the medical condition is unwanted hair by a 9-year-old boy who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and his puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age, can get that drug, but the other can't. That's the sex-based difference. It's not the medical condition is the same, and
we don't
but
agree.
You're saying one sex is getting it and the other's not.
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it to a minor who wants to transition. Those are not the same medical treatment.
wants.
What you're saying is,
well, that's your first mistake.
You're still depending on sex to identify who can get it and who can't.
I don't think so, Your Honor. If a minor comes up to a boy, goes to the doctor and says, I want puberty blockers to transition, the answer will be no. If a girl goes up to the doctor and says, I want...
If a sex-neutral looking child walks into a doctor and says, I don't want to grow breasts, doesn't the doctor have to know whether it's a girl or a boy before they prescribe the drug?
I don't think so, Your Honor.
I got to tell you, I've made that mistake on children often. Look at one of them and think it's a boy, and I'm corrected, and it's a girl, and vice versa. I hope that you're not going to tell me you haven't made that mistake.
Well, I may have made that mistake, Your Honor, but I don't think that that is an example of where a sex-based line is being drawn.
Why not?
Because
Yeah, please.
Because all that matters is the medical purpose for which the drug is used. So if the minor comes up, if you have a biological
No, it's the same medical purpose. Her hypothetical is, I don't want to grow breasts. Same medical purpose. I'm trying to stop the development of breasts.
Well, Your Honor, I think that likely would not be allowed under SB 1 for a girl.
For a woman who is, for a girl, but
yeah,
it
and
would.
it would also not be allowed under Tennessee law with respect to to a biological boy.
Really?
Tennessee law doesn't just allow doctors to prescribe drugs without a medical purpose. They can't.
No.
prescribe
The way I understood
testosterone
the law to work is it has to be inconsistent with your sex in order for it to be blocked. So I don't understand why a boy, I don't understand why it would work in the way that you're saying. Why wouldn't it be differentiating on the basis of gender? A girl who doesn't want to grow breasts for whatever reason could or could not get it.
does not want to grow breasts
Yes.
without a medical reason could not get it.
And a boy who doesn't want to grow breasts could or
What
could
about
not get
with
it.
a medical
Could not get it if
reason?
there was no medical purpose. There has to be a medical purpose for these
Okay,
drugs.
let's get into it.
My friend's arguments rest on conflating different medical purposes.
But they couldn't get it not under this
He doesn't
law,
think mental
right?
health is
Because
medical.
This law is operating around the inconsistency. So if they couldn't get it, it would be for some
He
other
doesn't
reason.
think body dysphoria
right?
is a thing.
But we have other
Or
laws in Tennessee
gender
law
dysphoria.
that prevent malpractice and that prevent the use of drugs for a non-medical
I understand,
purpose.
but this law is the one that is being challenged today, and we're trying to decide whether or not it's operating on a sex-based basis. And
Well, I don't think
we
we-
have so what about my lower voice hypothetical?
Yeah.
All right. So a biological boy comes in and asks for a hormone treatment to deepen his voice in order to affirm his masculinity because it hasn't come and he'd like to deepen his voice. Can he get it?
If there's no medical purpose, no.
No, that's the medical
I don't know that-
purpose. I don't understand what you mean. The purpose is to bring on a deepening of their voice.
Let me try to rephrase.
Yes.
If there's no medical condition, the answer is no. You cannot use testosterone for purely cosmetic reasons. It's a Schedule III drug. You
In
are
this
not allowed.
statute or in another statute?
In another statute.
Okay, so setting aside that other statute, we're looking at this one and how it operates. This statute says something about inconsistency with your biological sex, and that's what I'm trying to test. The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? Under this statute?
Under this statute, no, but under Tennessee Code annotated
The
63.
boy could not, under this statute, to get a medication that would deepen his voice?
If there was no medical condition, no.
That's the other statute. Under this statute, with respect
Under
to
this statute-
consistency, he could.
Under this statute, he could. Under
Okay.
63-6-214-12.
Oh, never mind. I changed my
I
mind.
understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone
Doesn't he
to
see
deepen
how
her
that
voice
just
in order
doesn't
to
make
affirm
sense?
The identity that she
To his own?
chooses, which is masculinity. I'm asking you, would under this statute, she be precluded from getting that treatment?
She wants to, I'm sorry, one more time, Your Honor.
She wants to get the medication in order to deepen her voice and affirm her masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be barred from doing that under
But
the.
isn't that the point, Mr. Rice, that if it's for the purpose of identifying with their sex, I mean, the prohibited purpose here is treating gender dysphoria, which is to say that the prohibited purpose is something about whether or not one is identifying with one's own sex or another sex. The whole thing is imbued with sex. I mean, it's based on sex. You might have reasons for thinking that it's an appropriate regulation, and those reasons should be tested and respect given to them. But it's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
Justice Kagan, we think that is a slightly, we think that's a request for a substantive right to engage in nonconforming behavior. We don't think it's actually drawing a line based on sex. And again, the only way that
is
my
that what we
friends
call
can
it?
point to a sex-based line is to conflate the use of puberty
Non-conforming
blockers to address
behavior.
precocious puberty with the use of puberty blockers to transition. And those are fundamentally different treatments. They have different effects on the body. They're used for different purposes. I actually think my friend's response to Justice Alito's hypothetical regarding puberty blockers is devastating, because that law draws no different lines than the law that's drawn in SB 1. It just doesn't use the words inconsistent with sex. So we use the words inconsistent with sex to describe a single prohibited medical purpose. We do not use it to draw lines between males and females.
Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult...
he's saying it doesn't pick one sex. It discriminates against both of them. Come on now.
May be. At the end of the day, legislation on this subject is subject to judicial review.
Yes, Your Honor.
And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of the scrutiny that's applied?
Yes, Your Honor.
Okay, thank you.
Counselor, given your argument, you're saying your state can block gender treatment for adults too.
Your Honor, we think that if we're assuming a similarly worded statute, that there still would not be a sex or a transgender-based classification.
So you're licensing states to deprive grown adults of the choice of which sex to adopt.
Your Honor, I don't think that's a fair characterization.
That's what you're telling me, because you're saying to me rational basis would be the review for that kind of law for adults as well.
And this court has not hesitated to hold laws unconstitutional under rational basis review when they are rooted in unsubstantiated fears and prejudices. That's exactly what this court did in Cleburne. And
That's
to the extent,
quite an interesting way to protect the population.
And to the extent, Your Honor,
I thought that that's why we had intermediate scrutiny when there are differences based on sex, to ensure that states were not acting on the basis of prejudice.
well, Your Honor, of course, our position is that there is no sex-based classification, but to finish the answer, that to the extent that a law dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
No, it's not. This is people's rights for their own bodily autonomy. Fuck off.
When you're 1%
You
of the
fucking Nazi.
population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
You blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
Mr. Rice, I have one factual question and then one legal question. The factual question is, the Sixth Circuit mentioned that this is an off-label use, that the FDA has not authorized. Is that still true, and is that just for children, or is it for adults too?
it's still true. I think with respect to both children and adults, I know with respect to children, I'm not certain with respect to adults. But we
Then
do
you
think
shouldn't
that,
answer.
That's relevant in the sense that the FDA, when it approves drugs, it does so based off of the purpose for which the drugs are being used. And we think that we are drawing the same type of distinction in our law between using one drug for different purposes.
Okay, my legal question is, I wondered if you had a response.
Oh, well, then
You know, I
we
was
shouldn't
asking your
use
friends on the other
drugs
side
that
about
help
du jour
do different things,
discrimination and
because
what we
there's
should
drugs
take
that have
account of if we're
multi-purpose.
thinking
So I guess
about
that's a no
whether
thing.
transgender people
That's
should
done.
be a suspect class for purposes of the 14th Amendment.
Forget it.
Do you have a response to that? What we should be thinking about, or whether do you know the history of du jour discrimination?
I do not know the history of du jour discrimination. I mean, our frontline position is that the court has gotten out of the business of creating new quasi-suspect classes, precisely because it's a very unprincipled test when it comes to creating these classes. And in some of the cases, political powerlessness means that you need protection from the majoritarian process. In other cases, it means can you gain the attention of lawmakers in the most recent Cleburne test. So the court has not applied any form of principled analysis when it comes to creating these tests. It's been an exercise of judicial power.
Nope.
And the intermediate scrutiny analysis that
Nope.
accompanies the quasi-suspect classification is no more principled, and the court has often struggled to apply that as well.
Not if you're
So
gay.
We don't think the court
You don't get to
should
take aspirin
even,
after your heart
open the
attack
door
anymore.
for further
Because they're making
judicial
decisions on
creation
what
of new
you,
quasi-suspect
who you are.
classes.
Okay,
Okay,
and last
so the
legal
law,
question.
there's
I
equal
was just gonna ask
protection.
you one, I have a second one.
That's what this
Could you
is.
address Justice Kavanaugh's questions about what the implications of this case would be for the athletic context or the bathrooms context?
I would love to.
God!
So we think
It's
this
like a
is,
checklist.
We differ with our friends
But yeah,
on
no
the other
HRT
side
for menopausal
with
or other
respect
anti.
to,
No.
Their
Nope.
argument is that, well, there's a sex-based classification in sex-separated sports, so necessarily that means that
No more
there's a sex
Viagra.
classification, intermediate scrutiny applies.
Blech.
We are not actually seeing challenges to the sex classification. When these challenges are being brought, they're not arguing that we don't want there to be boys and girls sports. They're arguing we want there to be boys and girls sports. We just want to be classified based off of our gender identity. And so we think that is a fundamentally a transgender-based challenge and not a sex-based challenge if you are not actually challenging the sex classification that is at issue.
Can I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been making a racial classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Your Honor, we think that in a case like Loving, when you look at the individual level, which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level, that if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race.
You are prohibited from a treatment based on your
I take your
birth
law to be doing
assigned
basically the
sex.
same thing.
Yeah.
You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So how are they different?
We think it's different because we think in their use of inconsistent with sex and all of these examples that they have in the briefing, those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not
And
only
what's your
different.
basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds being
I'm sorry.
asked.
I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and you recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
Can I ask you about one of the purposes of this law?
That's exactly what it is.
I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization of our law.
Encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like We want boys to be boys and we want girls to be girls.
If I could,
and that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
Your Honor, if I could make a few points. First of all, it sounds like the question is rooted in a potential improper purpose-based argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you know, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely, and I would love to address.
And what seems to have produced this classification is that we want to ban children treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So the appreciate their sex reference detailed in legislative findings, that is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes.
You're making
so
medical
I think
decisions
that
for
has to be
people.
viewed in the context of the legislative findings, which both emphasized the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions.
Stop
and
it.
in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research and that assessment of whether the findings of that study, but the legislature specifically noted those studies. So I think that statement was rooted in the notion that actually this is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.
Go ahead.
You go.
No, go ahead. No, go ahead. I'll be back.
Justice Kavanaugh.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state, particularly in a situation, as General Prelager said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports.
Yes, Your Honor. So as my friends recognize, the parental rights question is not before this court.
She explained how it informs, so just take the question as best you can.
Yeah, I think our position is that there are certain times in medicine, history has shown, where the states in their traditional role as regulators have had to intervene. And that's not because, of course, the parents are trying to do the best they can and get the best treatment for their kids. But we've had multiple instances in somewhat recent history where we have stuff like lobotomy, eugenics, that had widespread acceptance among the medical community, and the state had to intervene as a regulator to protect its children.
He stumbled a little bit on that last one because he knew he was full of
What you
shit.
started to say to Justice Kavanaugh, you agree that the parental rights question is not before the court, so it would be open to parents to continue to press that point in other cases.
We agree, and we think Chief Judge Sutton got it right, but we agree.
Can I just ask you about, I don't understand at all the similarly situated argument that you make, and I hope that you can help me, because I don't know how you can say both that girls and boys are not similarly situated at step one when this law is being evaluated and it's not making a sex-based classification. It seems to me that recognizing their lack of similarity as you do in making the argument is making a sex-based classification. So,
Your Honor, I think our position is that if you're in the point where we're treating giving testosterone to a boy with a biological deficiency as the same thing as giving testosterone to a healthy biological girl who wants to transition, then there has to be some threshold inquiry that recognizes the biological differences between those two.
right, but when you're doing that, you're making a sex-based classification. I mean, the very argument carries with it the characterization that we're trying to identify here. You start by saying it's different to treat a boy who's using this medication for a particular reason from a girl who's, okay, so that's a sex-based classification. Haven't we dealt with step one now? We should be going on to step two? No. Intermediate scrutiny applies by the terms of what you're arguing.
I don't think that we agree that we've checked the box at step one, because there is no medical treatment that boys can receive that girls cannot. So we disagree with the notion.
Didn't we already dispose of that kind of reasoning with our equal protection cases that looked at things like interracial marriage, where we said, even though it applies to both, it's still making a racial classification? Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged, we said. That's not an argument for why you shouldn't have a heightened scrutiny or why the statute is not making a race-based classification.
And that's not the argument that we're making,
okay,
Your Honor.
So what is
we
your
are not arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and you go in to get puberty blockers, you can get the puberty blockers if you're going to use them for precocious
I have a
puberty.
ton of articles from Journal of Adolescent Health
if you're going to use them
that I can share out after this, but this is just one of them.
Purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here, and the only way they get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.
And the treatments are different because of the biological sex of the person, right? I mean, that's what you said. The purposes are different because of the biological sex and why you're going in to get them.
Not at all. I mean, with puberty blockers, the purpose, nothing turns on sex. Take puberty blockers. There's nothing that turns on sex as to whether there's a sex-based classification.
You just said there was.
Everything depends on what is the reason that you are using those puberty blockers for.
But the law says about the sex. It doesn't say the purpose. It says the sex. Wait a minute. Happened? What
Happy to take
happened?
more questions if the court has them.
Justice Thomas?
A number of times you've mentioned off-label
Yeah, but we'll hear
uses,
from him again.
Of these hormones. What are some of the other off-label uses that are not legal in Tennessee?
So, for example, Your Honor, testosterone, we have a separate law that prohibits the use of testosterone for hormonal manipulation intended to increase muscle mass, strength, or weight without medical necessity. We have, like every state, we regulate medicine and we regulate the use of drugs. You cannot use drugs in the state of Tennessee if it's not for a legitimate, viable medical purpose. Here,
yeah, well, you
through
just
this
don't
law,
agree that it's a
all
medical
we have
purpose,
done
and
is make
that's
clear
you're wrong.
that these treatments, which are irreversible often, have significant effects on
Not
minors,
really
and
true.
often leaves them with bodies that are infertile and permanently damaged, that you have to wait until you turn 18 to receive those type of treatments.
He's trying to scale you.
A number of times you've tried to say what the classification that the state of Tennessee has advanced in this legislation. Would you spend a few minutes on that?
Yes, Your Honor. So again, we think that our law fundamentally draws a distinction based on medical purpose. I'll go back to puberty blockers. If a boy wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. If a girl wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. That is fundamentally a different treatment, and what is dictating
is that what
under this
SB1
law
says?
Is the use for which you are putting the drug. And just to kind of build out on the notion that these are not the same treatments, we talked about earlier testosterone. If you give it to a biological boy, it allows the boy to develop a normal body and healthy body, whereas providing it to a girl causes a physical condition, hyperandrogenism, and that results in clitoromegaly, atrophy of the lining of the uterus, blood cell disorders, increased risk of heart attack. So the notion that the risks
so there's medical
are
risks
the same
associated
when you give
with treatments?
testosterone to a boy
Are there risks for the boy? Are there risks for the boy? Are there risks for the boy?
Justice Alito? Justice Sotomayor? Justice Cade? Justice Kavanaugh?
Just one clarification. It's an obvious point, but I want to make sure you agree with it, which is you're not arguing that the Constitution takes sides on this question. You, as I understand it, you are arguing that each state can make its own choice on this question. And so from your perspective,
That's not the question before the court.
As I understand it, it's perfectly fine for a state to make a different choice, as many states have, than Tennessee did, and to allow these treatments, correct?
Yes, Your Honor, that's correct. And we think that's because of what Your Honor has pointed out, that no matter how you draw these lines, there are risk and potential benefits and harms to people on both sides. And the question of how to balance those harms is not a question for the judiciary, it's a question for the legislature.
Thank you.
Can states make a different choice if doing so means that a state's law operates to treat its citizens differently on the basis of name the suspect classification? I thought that was the work of the Constitution and the Equal Protection Clause.
Your Honor, we don't think that it draws any lines based off any.
No, I understand. I'm not talking about this law. I'm going back to Justice Kavanaugh's suggestion that the Constitution doesn't play a role if the state is making a policy choice regarding issues such as these. And I guess I'm still seeing a role for the Constitution in circumstances in which the claim that is being made is that the state's choices are implicating the equal protection rights of its citizens.
Your Honor, I think the point, I don't want to misstate the point, but I think the point is that the Constitution is neutral in the sense that it does not provide heightened protection based on any suspect classification, and thus rational basis review applies in the presumption of legislative validity and the presumption that these types of policy choices are best left to the democratic process. I think that is exactly what the correct way to think about this case.
No, it's not.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you, Mr. Chief Justice. Two quick clarifying points. I want to make clear that Tennessee here is not regulating based on off-label use. Off-label use is extremely common in pediatrics, and we've pointed to a number of uses of these medications on page 40 of our brief, the very same medications that likewise are off-label use. If there are problems with safety and effectiveness, then that would not become the standard of care, and there are self-regulatory measures to address that issue. Justice Kavanaugh, you said this might be a space where each state can make its own choice, but I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress, and so I think that the court should keep that in mind when thinking about the level of scrutiny here. There were a lot of questions about how to take account of disputed medical evidence when there might be some uncertainty, and I want to make a few points. As my friend acknowledged, that doesn't go to the level of scrutiny, so that doesn't mean that you should ignore a sex classification when one exists in the statute. But at the point of applying heightened scrutiny, the court can take context into account, and we're not asking courts to step in here and say, we want to figure out as a matter of policy exactly what the right approach is, but you can ask the familiar judicial questions like, does the state actually have any evidence to support its claims that there's a harm to adolescent health? And is this law severely over and under inclusive? And if the court conducts the analysis here in the first instance, this law doesn't look anything like a typical medical regulation to protect adolescent health. That would look like the West Virginia law, where you're tailoring it, but still leaving some possibility for care when it can have enormous benefits. And the reason it doesn't look like a typical medical regulation is because the legislature was doing something different in trying to get minors to appreciate their sex and not become disdainful. That's not a medical-based justification, but I think it shows exactly why the state drew the lines where it did. Finally, I think the court should think about the real-world consequences of laws like SB 1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care, and they say this is about protecting adolescent health, but this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health, but the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review. Thank you.
Thank you, counsel.
Boom.
Case is submitted.
Whoop, whoop. There you
The
go.
Honorable Court is now adjourned.
There you go. The Honorable Court is now adjourned. Well, Honorable's doing some heavy lifting there, but okay. I do love Justice Jackson and her amazing mind. We're very, very fortunate to have her. Imagine if we had had others. Okay, I want to show you just like a list. This is just a small list of the articles I found when searching for Journal of Adolescent Health and Transgender, because Dickweed makes a reference to, oh, there's a JA 400. I don't know if this is what he's talking about, JAH, but, and I'm not going to bother looking for it, but I'm going to tell you right now, if you just Google Journal of Adolescent Health Transgender, look at all the studies, understanding the mental health of transgender and non-binary youth. Gender-affirming care is evidence-based. Chosen name use is linked to reduced depression. Gender-affirming care is evidence-based. Okay? So there's plenty. Okay? There's plenty of evidence that we are harming children. Okay? You fucking TERFs out there? Are you listening? You stupid cunts? Yeah, despite the Nazi obsession with Jews, it was actually trans people who not. Yes, that's true. And I understand there was a lot. Yeah, trans individuals, trans people who are people, by the way, in case you forgot, have always been the subject of immense bigotry and violence. So, frankly, it's time for us to wake up and stop it, and to learn and to grow as human beings and to accept. And if you're so goddamn convinced that parents have the right to homeschool their children, well, then how in the world can you not allow those same parents to make decisions for their children when it comes to medical care, in concert with doctors and therapists and psychologists, and the expense? So, I'm going to tell you right now, nobody just wakes up and says, I think I'll do transgender stuff. This is who they are. This is saving lives. Period. So get over yourselves, you idiots who think you're saving anybody. You're not saving anyone. You're killing people with your hate. So stop it. Stop it. I mean it. All right. We have other stuff to do. I know we've been here for 3 hours, but I do have a few more things that I'd like to go over with you, if you don't mind. If you have time to stay. They come for yeah, exactly. And that's the thing. Oh, thank you, Oren. I can't get into my Discord right this moment, I don't think, but hold on. Let me see. Actually, let me go and see if I can get it and then drop it in here. Hold on. So everybody can have it. Everybody. Although, if you're not part of the Discord, what the hell are you doing? Oh my God. You better join the Discord. Hello. Oh, here we go. A leading researcher, Magnus Hirschfeld, a leading researcher of sex, sexuality, and gender, German-Jewish doctor Magnus Hirschfeld was forced to live in exile after the Nazi rise to power. I'm going to go ahead and clip this and I'll put it in the chat. Thank you, Oren. Let me drop this in the chitty chat. I'm going to drop this in the chitty chat. Oren's link. Okay, there we go. Thank you so much for that. Thank you so much for that. I know we're all doing this. Yeah, you cannot get much more marginalized than trans folks. So, you know what? This is exactly the type of stuff that we are going to have to be in action with in terms of standing side by side with people who are being completely fucking terrorized. So we are going to, like we need to be better. We need to be better. All right. I got other stuff. I got thrills. They're multiplying. Okay. Nope, wrong one. Wrong screen. Circa 2012, table of very well educated people doing crossword puzzle respond to my tangential grumble. Whoops, no, that's not what I want. I didn't want that. Why, Luigi? What do I got here? Why is that making it so big? Why is it so big? Okay, sorry, this is so tiny. Let me move this over. I guess I could. I think I can move this over here. Oh, no. Orange link. Wait, what? What does the pink triangle have to do with Nazis? Yeah, right. Exactly. There you go. Very disappointing moment. I can understand that. Yeah. Very disappointing moment. Because there were not just yellow stars, there were pink triangles. And that's how they identified people from LGBTQ plus during Nazi Germany. Yeah. Great. They're just great. All right. So this is Stephen Zeddy. This was shared by Gal earlier, but we were listening in. Shocker. In other shocking news, X has become a hotbed of neo-Nazi content under Elon Musk. We identified the operators of 4 anonymous accounts that share racist, anti-Semitic, and neo-Nazi content. 3 live in Texas. Musk has replied to 2 of them. 1 works for the Navy. Let's see. Who are they? Texas Observer. Revealed the operators behind 4 major neo-Nazi X accounts. Oh my goodness, it's so tiny. But it's just so tiny. Well, okay. I need you to really kind of help me out here. Okay. I just want to make sure. I say with my, no. There were a lot of symbols. I recently learned about the interracial kids in 1930s Germany. Thank you, Oren. Thanks for bringing that up. Nazis on shitter? Say it ain't so. Let me read you this article from the Texas Observer. Under owner Elon Musk, the social media site X, formerly known as Twitter, has become a hotbed of white supremacist and neo-Nazi content. A recent headline in The Atlantic doesn't mince words. X is a white supremacist site. Musk has allowed formerly banned far-right and neo-Nazi accounts back on the platform, and in some instances, he's directly responded to the accounts that traffic in white supremacist and neo-Nazi rhetoric. Meanwhile, anonymous accounts that regularly promote racial hate on the platform have seen their follower counts grow substantially as Musk has taken a more hands-off approach to moderation compared to the social media network's prior owners. Oh, such a genteel way of putting it. Let me move this one screen over so I can see the chat. There we go. I know. Let me go. Anonymity. 3 of the operators appear to have lived or have claimed to own property in Texas where X moderation operations are based and Musk resides. Though reviewing posts on X, web archives, leak databases, and other social media profiles, the Observer identified the following individuals as the anonymous operators of the neo-Nazi X accounts, which had a collective 500,000 followers at their peak. Cyan Cruz, a 40-year-old marketing professional who appears to have lived in Austin and Amarillo, and operates the X account, or is it Amarillo? I call it Amarillo. Okay, Amarillo, and operates the X account, the official 1984. Michael Gramer, a 42-year-old retired mechanical engineer who has lived in New Hampshire, operates the X account 9MMSMG and is claimed to have a house in Galveston and to be spending time in Dallas. Robert Bobby Thorne, a 35-year-old vice president at JP Morgan Chase in Plano. What? What? Who operates the account Noble 1945 and previously operated the Noble XX, and John Anthony Provenzano, a 30-year-old who appears to live in Virginia, operates the account Utism, formerly known as Johnny Bullseye. And according to a tip and a records request response from the U.S. Navy, works at the Naval Surface Warfare Center in Indian Head, Maryland, where the Navy manufactures explosive ordnance. What? I know, Val, there's so much to learn. So much. These individuals are part of a broader ecosystem of far-right accounts. I mean, that's why history is so important, everyone, right? We just have to fucking remember what happened. Not a lot of this is new. So we should have learned by now, right? Like, that's the thing. It's just why it's so important for us to have media literacy and to, like, really... Because we forget, too. Like, you know, you can put those things in the back of your mind and then not recall them. And then years later be like, oh, my God. You know, so I don't know. Sorry. These individuals are part of a broader ecosystem of far-right accounts that have rapidly expanded their reach in recent months. They are among the most popular white nationalist and neo-Nazi accounts on X, whose operators have not yet been publicly identified. While this article was in production, the Anti-Defamation League also identified Cruz as the operator of the official 1984. Their rise to prominence tracks with a dramatic decrease in moderation of hateful content on the platform, which dropped from 1 million moderated accounts in 2021. I'm going to read this very slowly. A decrease in moderation of hateful content on the platform, which dropped from 1 million moderated accounts in 2021 to only 2,361 accounts in the most recent 2024 X Transparency Report. 2,000. Posts from these individuals have received tens of millions of views over the last year and a half. These accounts have also attracted the attention of major public figures. 2 of the accounts have received replies from the X account of Elon Musk, who has said he writes all of his own X posts, and who, as reported by Mother Jones, has amplified users who promote pseudoscientific arguments that those of European descent are biologically superior. 3 of the accounts are followed by a sitting congressman, and many other right-wing media figures and outlets follow at least one of the 4 accounts. I'm going to remind you again that last week, yesterday or Monday, we watched a video where or maybe it was Friday, Elon Musk's father described his mother's parents as being actual Nazis in Canada who moved to South Africa because they supported apartheid. That's his grandparents. His grandparents were Nazis. Literal ones. Members of the party in Canada. I don't even know where we are now. 3 of the accounts are followed by a sitting congressman. I'm shocked there's not more. And many other right-wing media figures and outlets follow at least one of the 4 accounts. And this is their engagement. Follower count. Look at this. And this is over May 23 to November 2024. May 2023 to November 2024. All 4 accounts follow the other 3, and all 4 have interacted with at least 2 of the other 3 in posts, replies, and spaces on X. The host of a June 2024 X Space, an online voice chat room on the X platform, focused on JQ 101. JQ being an abbreviation used by anti-Semitic extremists for the, quote, Jewish question, which was how they referred to the Holocaust in Nazi Germany. Tagged all 4 of the accounts in a post promoting the gathering, in which 3 of the 4 accounts participated. Nearly 17,000 listeners tuned into the conversation. On July 9th, Musk posted 2 replies of Cruz's account, The Official 1984, which Cruz has used to post pro-Hitler, Holocaust denial, and other anti-Semitic content. Musk's posts were in response to The Official 1984's call to reinstate a prominent neo-Nazi account, Lucas Gage, who had been banned for 6 months. In the replies, Musk explained that Gage had been temporarily banned for repeated and clear calls for violence and identified one of Gage's many anti-Semitic posts as the specific reason. While Gage cannot currently post, his virulently anti-Semitic posts from prior to the ban remain visible on X, with many having hundreds of thousands of views. On July 23rd, Musk replied to Gramer's account 9mm SMG, in which Gramer has used to make posts referring to neo-Nazi tropes such as the 14 words and blood and soil, and identifying himself as a white nationalist. Musk's reply was a laughing emoji in response to a post about a community note, a feature that allows users to add context, that described Vice President Kamala Harris as former TV host Montel Williams', quote, main hoe, which 9mm SMG described as, quote, the greatest community note of all time. Musk's engagement with these accounts may fit a pattern of the mogul amplifying far-right views on X, including promoting Tucker Carlson's interview with a Nazi apologist in a since-deleted post and explicitly agreeing with an anti-Semitic conspiracy theory for which he later apologized. Musk's attention to the Official 1984 and 9mm account may also be due to the fact that they boast sizable follower accounts and verified blue checks, which can be acquired by paying a monthly fee for X Premium, or may be provided for free to those with more than 2,500 verified followers. I didn't get one. Verified users who pay for X Premium receive the opportunity to get paid for engagement from other premium users. In October 2022, Musk committed to in another post on X to ensuring negative hate tweets would be deboosted and demonetized and not generate revenue for the social media platform. In practice, this promise appears to have been sometimes broken. Sometimes? Which part of Twitter are you on? The Observer found advertisements in the replies to posts from all 4 accounts, including posts that featured pro-Nazi, anti-Semitic, pro-Hitler, or neo-Nazi content. On September 4th, the Official 1984 posted a screenshot of an email from X that said the account had been temporarily paused for revenue sharing for violating creator monetization standards, though ads, from which X likely profited, appeared in the replies of 2 of the account's posts later that same day. On October 7th, the Official 1984 posted that it had been permanently demonetized for violating the website's, quote, hate and extremist content standards. As of late November, the Observer did not find ads in the replies to the Official 1984's posts, though ads still appeared under the content of 9mm and Noble 1945. X didn't respond. These accounts have drawn the attention of conservative commentators, activists, and even elected officials. The X account belonging to Republican U.S. Representative Thomas Massie, massive asshole is what we call him, of Kentucky, follows 3 of the 4 neo-Nazi accounts. Well, that's because he's a Nazi. Hello. And while the account belonging to GOP Arizona State Senator Wendy Rogers, also a Nazi, follows 2. The accounts belonging to Sebastian Gorka, the former and future deputy assistant to Donald Trump, and Chuck DeVore, an executive at the Texas Public Policy Foundation, both follow 9mm. And this is Cyan Cruz. He's the one that's the 1984. I've seen him before. Cruz's account, the Official 1984, regularly posts anti-Semitic, pro-Hitler, and Holocaust denial content on X, racking up hundreds of thousands or even millions of views. His account was recently disallowed from receiving subscription or ad sharing revenue for violating X policies, but ads still appear in the replies to his posts. Cruz has now been identified by the ADL in addition to the Observer. In an April 2023 tweet, the Official 1984 mentioned another X account as Cy Rebel as his main account. This username is included in a 2023 Twitter data breach and is linked to the address cyancruz@gmail.com. Bummer. Google reviews associated with that email show the username 1984 and reveal a response from a reviewed business that reads, "Thank you for the kind review, Mr. Cruz." Oh, there you are, you big dipshit. You stupid ass. Further corroboration linking the username CyRebel to the name Cyan Cruz comes from Venmo and BandLab accounts that feature the name Cy Cruz alongside the username CyRebel. Cruz has an extensive digital footprint under the CyRebel username, including 2 publicly accessible dating profiles. Yeah, fuck yeah. On Tinder and Friend Finder X, the latter of which lists the same 1984 birth date that is listed for Cyan Cruz. You fucking idiot. You put your birth date. You thought that was so clever? Look at you, you stupid fucking prick. Man, the latter, which lists the same 1984 birth date as that listed for the only Cyan Cruz in public data, maintained by the Texas Department of Public Safety. Well, Cyan, I hope bad things happen to you. I'm sorry. I'm not the nice one. If you wanted the nice one, then you need to go somewhere else because I'm not the nice one. You should really be absolutely destroyed by this. I look forward to it. I look forward to your tears, Cyan. I sure do. Requests for comment directed to Cruz's email and phone number went unreturned. However, when messaged from an Android device, Cruz's phone number showed the username 1984 and a profile photo that reads Handy Rebel, the name of a defunct business that was registered under Cruz's name. Yeah, I hope he's really blue. I'm just so angry at these people. I think they're horrible. I really do. I don't wish good things for them, and that's bad, but that's where we are. That's where we are. The Handy Rebel business was formed in 2020 with Cruz as the managing member, listing his address as an apartment in Southeast Austin, and it forfeited existence in 2022. After sending a request to comment to the official 1984 account via direct message, the Observer's reporter was blocked from sending further messages. According to his recently deleted LinkedIn, some details of which can still be seen via data aggregator site Contact Out, Cruz has lived in Amarillo and Austin and listed himself as the president of Rebel Management Group, for which the Observer could not find a business registration in Texas. Which he also listed himself as CEO of Shining Star Management, LLC, which was registered with the Texas Secretary of State in 2015, listing an Amarillo address for Cruz and forfeited existence in 2017. Cruz, whose last name suggests and whose DPS database record lists that he is of Hispanic descent, may fit into a broader trend of Latinos drawn to neo-Nazi ideology. I haven't read the research on that. Here's 9mm. Oh, look at him. Look, Mommy. Look what I did. I took a picture and then I made some things on it. And that's what I did. Your dog looks upset. Gramer's account 9mm features anti-Semitic posts, references to neo-Nazi slogans, and concepts such as the 14 words in Blood and Soil, and discussions about National Socialism and fascism, which he has said he would prefer to our current democratic system. Well, then I have countries he could go to. He has also expressed admiration for Oswald Mosley, an early 20th century British fascist politician who espoused anti-Semitism and was closely associated with leaders of the German Nazi Party. According to his own post, Gramer is a white nationalist who attended a white nationalist music festival and discusses the JQ, but also insists he is not a fascist, neo-Nazi, or white supremacist. Oh, interesting. Hannah Gase, a senior research analyst at the Southern Poverty Law Center, said far-right extremists should be categorized by the words that they themselves say. If Gramer has any issues being called a neo-Nazi, then I don't know why he would reference a slogan coined by David Lane, who died in 2007, was a member of the neo-Nazi terrorist organization, The Order, and originated the 14 words. Gramer's account was created in September 2018, but saw rapid growth over the last year and a half. The earliest web archive of the account is from March 7, 2023, when it had 2,083 followers. By May 7, 2023, the account had nearly 10 times that amount, and as of this writing, it has more than 220,000. The email address behind 9mm, included in the same data breach as Cruz's, provided a first initial and a last name. That same email address was associated with a Google contributor named Michael Gramer that has posted reviews of businesses in the Boston area, as well as a Duolingo account named Mike. Mike. A number of personal details were revealed in 9mm posts. He says he is a New Hampshire landowner and resident whose first name is Mike, and his last name is German. He owns a summer home in Galveston, and he contracted for SpaceX, Boeing, Hispano-Suiza, and other aerospace companies. In an August 2024 post, he shared his age in an X post. ZoomInfo, a database and intelligence platform that aggregates detailed contact and business information, listed a Michael Gramer who previously worked for New Hampshire Ball Bearings, a company that has contracted with Boeing and Hispano-Suiza. Other than what's found on the Twitter breach, Gramer has a minimal digital footprint, though he has posted several censored pictures and apparently of himself on X showing distinctive tattoos on his arm and hands. Oh, look. Oh, my God. He's got cargo shorts on. He looks like a real meathead. Dick. Can we get rid of these guys? I mean, can we, get them fired and, destitute? Can we make them homeless? Can we do some? I'm sorry. I'm mean. But I'm just tired of people being so fucking mean. And I know being mean isn't the answer, but I don't care. I'm mad. After the Observer reached out to two people with apparent ties to Gramer based on Facebook posts and property records, 9mm sent a message on X. Hi, I've been told you have questions about me. I'm right here. When asked if he's the same Michael Gramer who worked for New Hampshire Ball Bearings, 9mm said yes. Gramer then defended the 14-word slogan, saying the words themselves are not extreme. Come on, stop being so stupid, you guys, before he stopped responding to other questions about his post. You know, the guilt is crazy. 3 weeks after we contracted Gramer, he posted on X that he was in Dallas and would be there for a while. In mid-November, Gramer posted that he had decided to spend the winter at a friend's rental house in Highland Park, a wealthy enclave in Dallas, where Gramer says he has, quote, a lot of friends. Here's Noble 1945, a.k.a. Robert Thorne. I haven't seen that account. Thorne's former account, Noble XX, was suspended for violent speech in mid-June 2024, at which time it had at least 31,000 followers. The specific violent tweet he was suspended for says, quote, the streets are a much safer place with both of them gone, referring to George Floyd and another black man who was killed by police while reportedly experiencing a mental health crisis. The account had previously shared pictures of swastikas, statements of Holocaust denial, and the phrase Sieg Heil, and had repeatedly identified its operator as a Nazi and a National Socialist. A second account featuring the same profile picture, Noble 1945, was created in October 2023, writing in one tweet, quote, if you're following me on this account, check out my main account at Noble XX. I'm only here because of a week-long ban on that one. This account is still active at the time of publication and has around 7,000 followers. Neither username NobleXX nor Noble1945 appear in the Twitter breach. However, another Twitter account with the same Twitter user ID, 313782690, as NobleXX with the username Fake Bobby Thorne, does appear in the breach. I'm dumb, mama. They caught me 'cause I'm dumb. I'm dumb. Oh, mama. They told me I'm dumb. The fact that these two accounts share the same user ID indicates that fake Bobby Thorne was switched to Noble XX at some point, explained Travis Brown, a researcher who has built tools to research and analyze X data. Every X account has a numeric identifier that is unique to that account and cannot be changed, said Brown. A particular account or tweet may have multiple URLs associated with it if the account owner changes the screen name, but the account ID will always be the same and can be found by viewing the source of the profile or tweet page in a web browser. This makes it possible to identify profile changes by comparing current account IDs and their screen names with IDs and screen names from archives such as the Wayback Machine. In one September 2020 tweet, fake Bobby Thorne replied to Goldman Sachs senior chairman Lloyd Blankfein, writing, Lloyd, we've missed you. Glad you're back. An email address linked to fake Bobby Thorne username in Twitter data breach appears in other data breaches where it's associated with street addresses and IP addresses in Salt Lake City, Utah. 3 private data aggregator sites tied the email address to the LinkedIn profile of a Bobby Thorne listed as vice president at J.P. Morgan Chase in the Dallas suburb of Plano. The same employment information appears for Robert Thorne in a database maintained by the private. I just love that they're going boom, boom. This is how we found you. Boom, 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 boom. You stupid idiots. So don't have problematic views, and then it won't be a problem if everyone knows who you are. I mean, that's it, or you're embarrassed but you have problematic views. We know why. According to the LinkedIn page, Thorne attended the University of Utah in Salt Lake City from 2010 to 2011 and previously worked at a Goldman Sachs between 2015 and 2022. The fake Bobby Thorne account was created in 2011 during the period that LinkedIn lists Thorne as attending the University of Utah. Noble posted an apparent selfie in June 2023 that facial recognition tools identified as a high probability match with both the LinkedIn profile picture and the old profile photo for the fake Bobby Thorne account. The apparent selfie was taken inside a gym. A Google account linked to Thorne's email address posted a review of the gym in Dallas, and a review of the gym's social media post and an in-person visit to the gym identified machines in a background matching the photo. Oh, you're so dumb. Look at you dumb shit. You roid rager. Fucking idiot. Oh, it was 3:05 a.m. What are you going to the Planet Fitness in the middle of the night because you're a lonely loser? Just kidding. Sorry. I'm just trying to be really mean. Thorne did not respond to requests for comment sent to his email address or a message left on his voicemail, but his mom did make him a hot pocket. In response to a request from comment from the Observer, Michaela Ross, Vice President of Media Relations and Executive Communications with J.P. Morgan Chase, responded via email. The employee in question is on leave while we complete our investigation. We do not tolerate hate speech of any kind. I would like to find out that he's been fired. All right, here we go. John Anthony Provenzano, Utism. I've never heard of this guy either. I'll let you know when I give a fuck. Oh, well, no worries. Prior to being deactivated in October, the account Utism, screen name Bullseye, had around 70,000 followers and regularly posted pro-Nazi, pro-Hitler, and anti-Semitic content. Based on memory.lol, a tool developed by Travis Brown that tracks changes to X accounts, the account appears to be the second or third account created by the same user after prior accounts with the username Johnny Bullseye were suspended. An old profile photo preserved in web archives from when Provenzano's accounts was still named Johnny Bullseye features the same words in a circle around the photo as the Utism account. You've just been fucked by psyops because physical wounds heal. I know. Well, they don't. I mean, again, you're right. I forgot what happened, Max. Thanks for the reminder. Damn it. The old profile photo provided a face that image recognition programs matched with high probability to photos on other social media platforms, including an old Facebook account named John Anthony with the username John Provenzano 0 or Provenzano. Okay, so this is Bullseye John Anthony. Is that him? What? All right. I can't really see these that well. Let me see if I can make him. You can't really see him, but you kind of get a point. You get the point. All right. Oops. Oh. Steven. Wait, where's my wait. Okay, here we go. All right. A database of hacked or leaked emails shows that Provenzano used the same username to create accounts on other websites that were associated with emails that include his first initial and last name. Public traffic citation records link Provenzano to an address in the area of Arlington, Virginia as of 2020. Employment and location information for him also appeared in the employment database LIDAR and other private databases, indicating that he has a work history as a project engineer for construction companies in Virginia. In the course of investigating Provenzano's background, the Observer received a tip that Provenzano had taken a civilian job at the Naval Surface Warfare Center in Indian Head, Maryland, about an hour away from Arlington. When asked about Provenzano's employment and apparent posts on X, a public affairs office at the Naval Surface Warfare Center at Indian Head provided the following statement. The Navy has a zero-tolerance policy for extremist conduct and takes all allegations of personnel involvement in extremist groups seriously. These allegations are under investigation. It would be inappropriate to comment further. A response from the Navy to Observer Freedom of Information Act requests from Provenzano personnel records provided further evidence of his employment there. Upon our review, we are withholding any records that would be responsive to such a request pursuant to FOIA, which allows the government to withhold information about an individual employee where the disclosure of such information would constitute a clearly unwarranted invasion of personal privacy, the response reads. By contrast, the Observer previously requested records in another case about a different extremist who had expressed interest in joining the Navy, and the Navy responded saying it had no records. Provenzano did not respond to requests for comment. Less than a week after the Navy provided comment for this story, the UTISM account was deleted. And that is Steven. So there you go. Let me see. I actually have maybe a couple of other things. Oh, I want to read this before we go. This is from Craig Mauger in Detroit News. I think I can read the whole thing. I don't think I'm caught off. But this was disturbing. Lee, I think you sent this to me or highlighted it. If you're still here, I'm not sure, but I believe you did. Michigan GOP lawmaker says gay marriage should be illegal again. This is from December 2nd. Republican Michigan State Representative Josh Shriver said Monday that gay marriage should be illegal again, voicing opposition to a U.S. Supreme Court decision that set the standard for the nation and spurred same-sex weddings across the country 9 years ago. Shriver of Oxford made a statement on the social media platform X after the 27 days after the November 5th election, in which the Michigan GOP won back control of the state house and 30 days before their majority takes office. Because gay marriage is legal in Michigan and elsewhere through a court ruling, Shriver can't alter the policy in his position in the state house, but his remarks likely shine light on how one member of the new majority caucus of the House will approach LGBT legislation. Make gay marriage illegal again, Shriver wrote Monday. This is not remotely controversial nor extreme. Well, fun fact, Shriver, it fucking is. Okay, it's both. So go fuck yourself. However, he received a swift backlash from Michigan Democrats. I hope he received a swift backlash from Michigan Republicans, including Attorney General Dana Nessel, who's a badass, who previously represented the two Hazel Park women who were part of a landmark lawsuit that opened the door for all same-sex couples to legally marry in the United States. Nessel is also married to a woman, Alana McGuire. The couple married in 2015. Quote, please explain how dissolving my marriage or that of hundreds of thousands of other same-sex couples living in America provides a benefit to your constituents or anyone else, Nessel wrote on X in response to Shriver Monday. You're not interested in helping Michiganders. You only want to hurt those you hate. Shame on you. In addition, Rep. Jason Morgan from Ann Arbor, who is also gay, posted on social media that Shriver was, quote, saying my marriage to the man I love should be illegal. This is definitely both controversial and extreme, along with anti-family, Morgan said. I grew up believing I'd never be able to get married, and I'm not going back. In a 5-4 decision, the U.S. Supreme Court legalized same-sex marriage on June 26, 2015, citing the due process and equal protection clauses, remember those, of the 14th Amendment to the U.S. Constitution. The court now holds that same-sex couples may exercise the fundamental right to marry, wrote then Justice Anthony Kennedy. No longer may this liberty be denied. Unlike in 2015, the U.S. Supreme Court now has a 6-3 conservative majority. Asked why he wants to ban gay marriage, Shriver, who's in his first House term, responded to the Detroit News by referencing a series of Bible passages. Jesus defines marriage as between a man and a woman, Shriver wrote, while citing verses in the book of Matthew. Oh, good for you. In a text message Monday evening, Shriver noted the U.S. Supreme Court has the power to overturn a past ruling. Yeah, well, man, I'm so done with the idiots. Shriver also posted on social media Monday a 2004 clip of Democrat Barack Obama discussing marriage between a man and a woman. Yeah, and we were really mad at him. We were really mad at him for that. He had to apologize. America only, quote, accepted gay marriage after it was thrusted into her. there's a lot of penetration right now. Okay, there's just too much penetration right now. Okay. It's too much. Obama came out in support of same-sex marriage in 2012 while he was president. Shriver, who won a second term in November, was 68% of the vote. God, my God, it's, you know what? It's not these guys, it's the people who vote. Ugh, has made controversial comments in the past on social media. No shit. In February, Michigan House Speaker Joe Tate stripped Shriver of his office staff and budget and committee assignment for sharing a racist population conspiracy theory on social media. Jim, where are you going? Oh, you're finishing up the gumbo. Yum, yum. His post about gay marriage Monday came after another message on November 25th in which he said he was turning off his social media devices in 7 days and going. He said he was going on a trip with his family, but he bothered to post. Tomorrow's going to be in the low 30s. That's Florida, right, Jim? You're in Florida, I think. Holy shit. Yeah. 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 I'm not going to read it, but well, actually, maybe I will read it because I wanted to kind of close the loop on this. How long is it's not very long. Oh, I'm going to do this. This is super short. Okay, I wanted to kind of close the loop on something we missed yesterday, which was there was that hearing in Georgia about records being turned over by Fonnie Willis. Remember that? We even watched a little bit of it when Ashley Merchant was standing there with her big shitty ass and trying to bully people into giving her records when she wasn't even clear. It's just all a political game. You know, remember Ashley Merchant, the one whose client, Mike Roman, is actually guilty of trying to overturn the 2020 election? Remember that one? Okay, well, she's worried about these records about Fonnie Willis, boinking one of her. Yeah, so that's it. That's why we can't have nice things. Just so you know. Oh, I'm just sorry. There's just there are some positions in the world that are fundamentally wrong. Wrong. Just wrong. That's why it's not like, oh, why can't you guys unify? Because your positions are incorrect. Ugh. All right. Anyway, I wanted to read this before I leave you today. And this is about what happened yesterday in the thing that we missed. I know. Stay warm. From Oxford. Oh, right, exactly. From Oxford, where the parents were prosecuted and for their child shooting people in his school. That's right. That's right. All right, here we go. Fulton DA Fonnie Willis ordered to turn over records of Georgia Trump investigation. Judicial bitch ordered it. A Fulton County judge has ordered the Fulton District Attorney's Office to turn over documents from its election interference investigation that were sent to Special Counsel Jack Smith and the U.S. House Jan 6 Committee. On Monday, Superior Court McBurney ordered the DA's office to turn over the documents to Judicial Watch, which is Tom Fitton, which is Mr. Schmedium himself, Mr. I take steroids before anything else. Yes, I'll have some steroids with my Whopper. On Monday, McBurney ordered the DA's office to turn over the documents to Judicial Watch, a conservative nonprofit, no shit, within 5 business days. Quote, Judicial Watch looks forward to getting any documents from the Fonnie Willis operation about the collusion with the Biden administration and Nancy Pelosi's Congress. You know, remember her? On her unprecedented and compromised Get Trump prosecution. Judicial Watch President Tom Fitton said in a statement. This is bad, okay? I'm getting really upset and depressed, frankly. There's Tom Fitton. He's a fucking dick. And he should go away too, permanently. The Fulton DA's office referred the matter to the county attorney's office, which represented Willis in the lawsuit brought by Judicial Watch. County Attorney Sue Joe did not immediately respond to a request for comment. In August 2023, the DA's office obtained a racketeering indictment against elect Trump, 18 co-defendants, although 4 of them have since entered guilty pleas. The case is now on hold while the Georgia Court of Appeals considers whether the DA's office should be disqualified because Willis had a romantic relationship with former special prosecutor Nathan Wade. On the same month the Fulton indictment was handed up, Judicial Watch filed an Open Records Act request with the DA's office seeking records it sent to the special counsel's office and the House committee. When the county attorney's office said the DA's office did not have them, Judicial Watch filed suit this past March. In a 6-page order, McBurney found that because the county attorney's office had not met the filing deadline to respond to the lawsuit, the DA's office must be found to have violated the Open Records Act. Moreover, McBurney found the office is in default and must turn over to Judicial Watch any records that are not legally exempted from disclosure under the Act within 5 business days. The Act shields records from being disclosed if they are part of an ongoing investigation. McBurney also set a December 20th hearing to decide how much Fulton County must pay Judicial Watch in attorney's fees. Yeah. Yeah. Yep. That's what happened yesterday. That's what we missed. Oh. Gender, not geography, yeah. Nice crowd outside the Supreme Court. They're getting ready to leave. Oh, cool. Unicorn Riot was streaming. Cool. Coolio. Cool. I don't think I can restream Unicorn Riot. I think they'd get mad. But look up Trump's Agenda 47. Yeah, no, I have. Oh my goodness. Yes, I have. It is Project 2025. I don't know. Well, folks, it's been 4 hours and we've learned a lot, I think. I hope you learned something, and I hope you got a little bit of joy out of this morning. I certainly did. Really brilliant arguing on behalf of transgender people. So appreciate the state attorney general and also Chase Strangio, the first transgender attorney to argue in front of the Supreme Court. And so that was quite amazing. Ford Fisher is there. Yeah, Ford and I don't really get along. I mean, I kind of appreciate what he does, but there's moments when he and I clash, but he doesn't really care. It doesn't matter. I have a feeling that there's a lot of toxicity over there right now, Max. I'm just going to guess. Or maybe they're too lazy to show up. I don't know. Could be toxic, could be lazy. I don't know. Convenient protesting. I love it. Anyway, my brain is full. My brain's full. My brain is full. My heart is full. I love you too. Hope everyone has a great day. I'm going to be away tomorrow. Oh, all right. Well, then we are sending you huge love, Oren, and calmness for your tests tomorrow. And I hope you get the news that is good and that your healing is fast. And we will be here. We'll be here when you get back. We'll be here when you get back. Jim, what? Source, please. Once he gets into office, he's going to pass a law wherever you have to remain. What? I haven't heard that. I have to read that. What part of it is? What part of it is that? Yeah, thank you. Thanks, everyone. Ford Fisher's chat is always toxic. Yeah, think about who shows up to it. You've got some pretty toxic people there. I know. Break a leg. That's right. Break a leg, Oren. I love you guys. Have a great, great Wednesday. And I hope I see you soon. And one of these days I'll come online at night and we'll do some reading or we'll play some games. Oh, wait. What am I saying? Tonight's Wednesday. We got to do a documentary tonight on Discord. It's documentary night on Discord. I have a couple of ideas, but if anybody has like an idea for a documentary they want to watch tonight, just send it to me, okay? Okie dokie, okie dokie. All right. Yeah, tap dancing aliens. Hell yeah. All right. Okay, it's movie night tonight. It's a movie night. I have a couple of ones, but if you have any we got to watch this, just send it to me anywhere. Okay? All right. Probably six. Oh, you dropped one in Discord? F yeah. I'm going to take a look at it. All right, good. And then Friday night is fun movies. So you got to be thinking about that too, because I haven't thought of any fun movies for Friday night. So I need input, people. This is a collective. This is not, Anyway. All right. I love you guys. Have a great Wednesday. I'll talk to you later. Ciao.